Good evening. Welcome to the October 19th, 2023 meeting of the Portsmouth Planning Board. I'm going to call the meeting to order. We have a full board except for Mr. Mahana this evening. Mr. Simonis, will you sit for Mr. Mahana?
Yes.
Just as an announcement to everybody, the agenda has been split. Items 4A through E will be heard this evening. Items 4F through K will be heard next week. We're having a special meeting next week for that purpose, except for item 4I, which is Lonza. That'll be on the agenda. They've requested a continuance to the November 16th meeting. First item on the agenda is approval of the minutes for September 21st and September 28th. Ms. Bill.
I'd like to suggest that the minutes of the September 28th meeting reflect not the full discussion that was had. There was a view by the city attorney that was administrative in nature, and then there were other views presented by other people. Particularly, there's a set of on the role of the chairman. There's a perspective of what's recommended by the New Hampshire Municipal Association, which would play a different role for the chairman than what is suggested in the minutes as written. So at some point, I think we agreed there would be a future meeting where there'd be further discussion of the bylaws, and that would be one of the things we would discuss.
Yes, as a point of information, there will be one more meeting before the next planning board meeting on that topic, where I'll be meeting with the city attorney. There was a miscommunication between the two of us, and each thought the other had notes. So those have to be reconstructed before we can have the meeting. In addition, in order to actually vote on the proposed amendments that we have pending, that has to be properly noticed based on the current rules. I'm hoping that will happen not next week, but probably at the following planning board meeting. So that'll be reflected in, the minute I looked at them, and I think the minutes reflect some of what took place, but not necessarily all of it. But, Jim.
Yes, Mr. Chair, I'd like to reiterate what Mr. Bowen said about them. The minutes in general are just very sparse. I don't think they captured the essence of the meeting. So I don't know. I can't list all the specifics, but I think the minute takers should go back, look at the video, and beef those up.
I think we don't have to necessarily accept them. We can have them wait if you want.
Certainly, you can
Postpone.
postpone.
Put them on file. Basically,
You can postpone, and we can bring them
back later.
Additional
I think
edits.
we have a busy evening ahead of us, perhaps. So if that is what somebody would like to do, you can make a motion to that effect. I can't.
I would make a motion to postpone the minutes.
Second. Is this just the
I was just
928?
Is it both or one, just one?
I think you were just talking about the work session.
Just the work
No.
session minutes, right?
Yes.
Just 928?
Yes.
The motion to postpone 928. All those in favor?
I
Opposed? How about 921?
make a motion to approve the minutes of September 21st.
Second.
Any discussion? All those in favor?
Aye.
Opposed? Adopted. Just give me a second here. My computer has decided to act up a little bit. Have determination of completeness. We have Banfield Realty LLC, owner for property at 375 Banfield Road, requesting to subdivide one lot into two lots to create the following: proposed Lot 1 with 6.65 acres of lot area and 354 feet of street frontage, and proposed Lot 2 with 7.96 acres of lot area and 200 feet of street frontage. This property is on Assessor's Map 266, Lot 7, and lies in the industrial district. We also have the same applicant requesting a site plan review approval this evening, which I will read if the board wishes to have completeness on both applications.
Do we have to have a motion to suspend the rules to do that?
It's determination of completeness. Why don't I just read it, and if you want to accept both. The other one, because then we can move into action after we finish the completeness. So for Banfield, the other one was Banfield Realty LLC is owner for property, again, at 375 Banfield Road, requesting site plan review approval to demolish 2 existing commercial buildings and an existing shed and construct a 75,000 square foot industrial warehouse building with 75 parking spaces, as well as associated paving, stormwater management, lighting, utilities, and landscaping. Again, this is on map 266, lot 7, and lies within the industrial districts.
Move to approve.
Mr. Chair,
Yes.
I felt the application was not complete for both subdivision and site plan. I would have preferred a copy of the pending lawsuit and an explanation from the legal department of where that stands and how, with Portsmouth being a defendant in that lawsuit, how our actions may or may not affect the outcome of that lawsuit. So, at least for me, I know it's unusual. I don't consider the application complete because I felt I needed that information.
Okay, I think the determination of completeness is an initial step before conversation about the application and the substance of it. It is not a determination of acceptance of any of the items. I understand your point is that you feel something's missing. I don't think that the lawsuit is actually something that falls within the purview of our regulations, but I have asked the Deputy City Attorney to be here this evening, and he's prepared to address that. I think that would be something, perhaps, if the board is inclined to accept the applications as complete so we can proceed, we could bring that up at the time of when we begin our deliberation, would be my recommendation.
I did make a motion.
I'll second it.
So we have a motion to accept the subdivision and site plan review approval applications as complete.
I had a question about the,
Discussion now. Yes, Peter.
so in the packet, there was a memo from Technical Advisory Committee, or TAC, that they had to provide proof of cleanup responsibility required for planning board approval. And I just, for the record, I guess I want to make sure that that's happened.
To my understanding, that is in the package, but that's, again, that's a substantive discussion about the application. That's next step. So
Okay.
we get into, once the application is accepted, next steps are to have the applicant and us talk about it, then a public hearing, and the other steps that ensue. This is just about completeness. Any other discussion on completeness of those two applications? All those in favor?
Aye.
Opposed?
Opposed. Opposed.
Two opposed. We have a request of Caleb B. and Samantha L. Ginsburg as owners and Peter and Donna Splain as owners for property at 303 Bartlett Road and 295-299 Bartlett Street, requesting preliminary and final subdivision approval for a lot line relocation between tax map 162 lot 13 and lot 14, where a separate parcel was discovered between two lots and is proposed to be divided between lot 13 and 14, so that lot 13 increases in size from 4,906 square feet and 36 feet of frontage to 6,665 square feet and 37 feet of frontage. Lot 14 increases in size from 4,802 square feet and 192 feet of frontage to 8,640 square feet and 217 feet of frontage. This property, again, is on Assessors Map 162, lots 13 and 14, is in the GRA General Residence Districts. Completeness?
Motion to approve.
Second.
Any discussion? All those in favor?
Aye.
Aye.
Request of Richard and Jessica Hayes as owners and William and Katya Becker as owners for property at 40 Walker Bungalow Road and 26 Walker Bungalow Road, requesting preliminary and final subdivision approval for a lot line relocation to remove the encroachment of a driveway and retaining wall as follows. Tax map 222, lot 5-1, consisting of 53,970 square feet of lot area, increasing in frontage from 140 feet to 160 and 1,700 feet with no change in lot area. Tax map 222, lot 5-2, consisting of 37,637 square feet, decreasing in frontage from 120 and 1,700 feet to 100 feet, with no change in lot area. This property is in Assessor's Map 222, Lot 5-1 and Lot 5-2, and is in the Single Residence or SRB District.
Motion to approve.
Second.
Discussion? All those in favor?
Aye.
Opposed? Correct me if I'm wrong. Public hearings.
Right. This will be next week. Yep.
We have, first item, under public hearings, old business. We have a recommendation from staff that items 3A, B, and C be discussed together and voted on separately. Motion to that effect would be
So moved.
useful.
Second.
Any discussion? All those in favor?
Aye.
Opposed? Items 3A, B, and C will be discussed together and voted on separately. So that everybody is aware, the procedure in public hearings, which everyone is required to follow, is the public hearing. The public hearing of the planning board will start with a presentation by the proponent, questions by planning board members, public comment to, for, and against the application. Please limit your comments to the agenda item. Comments directed to the chair. Do not direct them to anybody in the audience or any of the planning board members. You have 3 rounds of comment as a member of the public, which can include the applicant if the applicant chooses to speak during the public comment period. First round is 3 minutes. Second and third rounds are 10 minutes each. Please yield your time. There's a timer up here. There's buttons with lights at the podium. Green light is you're good to go. Yellow light means your time is getting short. Red light means your time is up. Please wait for, if you're a first round speaker, wait for the second round, finish of the first round speakers before you speak to the second round, et cetera. After that, the public hearing is closed. We consider motions on the application proposal, discussion of the motions, and public comment has finished. No comment once the public hearing has been closed. With that noted, who is here to present for Banfield Realty LLC? As the
Good evening, everyone. My name is Courtney Hers. I'm an attorney with Sheehan Finney. Here tonight with me, Rob Graham from Banfield Realty, Joe Coronati from Jones and Beach, the engineers, and my partner, Lynn Preston. I will turn it over to Joe in just a minute to talk about the details, but I just wanted to give a quick introduction. As you all know, and I won't go into too much detail because you know this, the project is at 375 Banfield Road. The proposal is to remove 2 existing commercial buildings and to construct 1 new industrial warehouse building. As you folks likely know, the applicant, Banfield Realty, has been working closely with the Department of Environmental Services and the U.S. Environmental Protection Agency to properly remediate contamination that was present on the property prior to Banfield Realty purchasing it. The application includes extensive information about those efforts. And what's important for you folks in terms of the issues that are before you tonight is that the proposals that are before you tonight are consistent with those efforts to remediate the contamination and the work that's being done in collaboration with DES and DPA. The application, as indicated in the materials submitted to you, indicates that the applicant will comply with the requirements of DES and EPA going forward. As you know, we were also scheduled to be heard here last month. When requested a continuance, there was a separate issue dealing with an easement on the property held by the city. And thanks to city staff for meeting with us last month probably. We've been able to work that issue out such that the changes to the plan leave the easement, the grade of the property in the easement area exactly as it is. So that issue seems to be addressed, I think, in a way that works for all parties. I want to quickly touch on a couple comments that came up during the completeness review. As you indicated, Mr. Chair, the pending lawsuit is pending for sure, but it doesn't implicate the issues before the board here tonight. The regulations tell the board what needs to happen here, and that's outside the purview of the board to deal with the issues of the pending litigation. And with regard to the question about the tax comment about proof of cleanup responsibility, I would direct the board to page 20 of our subdivision application, which indicates how, if the subdivision is granted, how the two parcels would be owned. And also to page 6 of the staff memo, where the staff has indicated that the applicant has satisfied that comment from the TAC. So at this point, I'll turn it over to Joe, and certainly.
Before you leave.
Yes.
Obviously, there was a huge package of materials, thousands of pages of information.
Correct.
And from last meeting to this meeting, you were kind enough to provide a summary, which was helpful, which was limiting the focus of the board to approximately 250, 260 pages. I'm concerned that one of the items, more fairly recent April of this year letter from DES was on page 2,417, I think.
2,489. I have it in front of me, that's all.
So my question is twofold. One is, why was the package so large? And two, this is a volunteer board. I don't expect the board members to have studied all 2,800 pages or whatever it is. Can you provide assurance that we can rely on a certain number of those pages, as is indicated in the cover letter, or not?
So, yes, and I appreciate that, and I understand it was a huge packet. Wanted to be as complete as possible so that there was information if folks had questions that we could point you to. And so as you noted, a large chunk, thousands of pages of it, have to do with the reports submitted to DES, and therefore if there were questions, we can point you to those pages. But yes, you can rely on, I'm looking at our cover letter, trying so I can get you the exact pages. We consider the first pages 1 through 259 to be sort of the application that give you what you need, but the rest of it is there so that if we need to point, in response to any questions you folks may have, that we can direct you to those pages. I hope that answers the question.
Before you leave, yes, Jane?
Yeah, I actually did have a question.
Sure.
Based on your statement that this has been properly remediated. Again, referring to that New Hampshire DES letter dated April 23rd, 2023, on page 2,489 and 90 of our packet. Whereas I see that New Hampshire DES is saying, yes, we got, your revised work plans and your revised remedial action plan, and they're saying that they are, what's the word? Acceptable. They're acceptable plans. That is different. And this is the point that I'm asking about. That is different than having completed all of the work in these action plans that were meant to be action plans implemented. So my question is, on page 2,490, there are, the second bullet from New Hampshire DES says that they're still concerned about a greater density of sampling points within and near the stream channel, and that should be completed as part of the spring 2023 assessment work. I don't see anywhere in our packet where it says that specifically was completed, nor in two more bullets where it says that they want a summary report with the results of all the additional investigation activities within 120 days of receipt of this letter, which means that I should be able to find something dated July 2023 in the packet saying that was done. That's just for the lowlands, and then there's a whole section for the upland. But can you speak first to the lowlands part of that, about what the verb tense is? Is the verb tense its planned action? Or is the verb tense that all of these things, in fact, have been completed? And if it's the second thing, where is there proof of that in our packet? Specifically, what page?
So the work is not completed. I'll answer your question directly. The work is underway. It's been approved by DES, and we've been working with DES and with EPA. It's a long process, but I don't see, I'm looking at 2,490. I'm not sure what you're looking at there because I see it, what I'm looking at.
In your package, it's 2,417. She's referring to our overall
Okay,
package.
okay, all right, thank you. But stepping back more broadly, I would suggest to you that the question of remediation is outside this board's purview. Remediation of the contamination of the property is being handled by DES and EPA. It's within their purview, and we're cooperating with them. We're here to assure the city that we're cooperating with them. But what governs the decisions before this board tonight are the regulations, the site plan regulations and the subdivision regulations.
Okay, but excuse me, I beg to differ. I know I'm not a lawyer, et cetera, but when I look at our own table of uses in our own zoning ordinances, the very definition of an industrial site literally says that the use, and I have a number of questions later on about exactly what your warehouses are doing, but our zoning table says that the use does not allow for recycling, high hazard use, et cetera. So it restricts the types of things to be stored or the types of things to be manufactured because of the concerns about pollutants and other, it lists liquid petroleum products, et cetera, et cetera. So even it being an industrial zone does say that this can't be hazardous. So
Okay, I'm gonna just interrupt here a little bit. I think I'm going to call on the deputy city attorney to assist with this, but I have to tell you, I'm in agreement with what the attorney just said. Our regulations do not cover a lot of this. If you were proposing to put a warehouse that would be producing hazardous materials, that's what you just read. This is a situation where the site has been contaminated previously. It is a problem. It has to be addressed. It is being addressed, but it's not a part of our current regulations, in my opinion. Now, I'm interested to hear if the deputy city attorney agrees with that.
So, Mr. Chairman, can I just ask you then, why then did I literally spend 2 days of my time reviewing a packet that includes all of these specifics, that includes these letters from EPA and New Hampshire DES, if it's not part of the, was I only supposed to look at pages 1 through 259? Because by the time I got that, it was too late. I get very confused about the amount of material we've been given here to consider, which I have done, and then being told that we can only look at the site plan.
There's an interrelation between some of the elements of what this site is and what we have to look at for site plan and subdivision regulations, again, in my opinion. For example, there's concerns expressed in some of the reports that you would have read if you read Beyond 260, as I'm sure you did, about trespassing people being exposed to contaminants. That's something that may be a concern. And I stress it may be a concern. I don't know if it's a concern of the board. That's something that does fall under site plan regulation review for fencing and things like that. But for example, let's make it very simple. Let's say an applicant is proposing a subdivision in an area that requires septic systems out in areas that are not serviced by infrastructure. That requires state approval. We are not allowed to not approve without that approval being in hand first. We can only condition an approval expecting that the state will take care of that later. This is a similar situation that the state and the federal, I assume the federal government has some jurisdiction as well, but the city, this board anyway, is constrained by our regulations, and they do not extend to include cleanup activities. I'm an engineer. I don't know how to review that.
Right, but until that's still hovering around my area of questions because I'm not clear about whether we can or should approve something before all of the conditions stated in the last letter from the New Hampshire DES are met. I don't have to measure whether they're met, but I think evidence of them being met should be like, could be provided in a July 2023 letter that says, we did this, we did that, we did that. I mean, and then it goes through our TAC, et cetera. But to approve this project before I know that the things included in our packet were met, I'm not comfortable with doing that, I guess.
Okay, I guess that's two questions. Would you like to speak to that first, and then the city attorney, deputy city attorney will speak to it?
Certainly. And first of all, I appreciate your and all folks' time reading all the materials. I know there's a lot, and I know it's dense, and so I definitely appreciate everyone's time on that. I agree with you, Mr. Chair, that this is within the jurisdiction of DES and EPA. What's this board's purview is to decide whether the application meets the regulations for subdivision and for site plan. And so to the extent, everything that's been submitted is showing the cooperation that the applicant is engaged in with DES and EPA, working through the process. The process takes a long time, but there is nothing within the regs, and there's nothing within any of the materials before you that says this whole property that has been contaminated for a long time, long before this applicant purchased the property, that all the cleanup activities need to be completed before any work can be done on the property. That's not contemplated by the regs, and it's not proper under the application and under the requirements governing this board. So I don't know if that answers folks' questions. I'm happy to step aside for the deputy city attorney.
Attorney McCord, if you could approach, and I think if you could address that topic and also the lawsuit question, I think that would be helpful.
Certainly. Thank you, Mr. Chair, members of the Planning Board. My name is Trevor McCord. I'm Deputy City Attorney. To take the lawsuit first, because I think that'll be the quickest to work through, I spoke with our outside counsel in that case over at the McLean Law Firm, and they specifically advised that this board and the Technical Advisory Committee, when it was before that committee, do not consider the pending lawsuit at all as you work through your criteria, and I agree with that recommendation. While that lawsuit is pending out there, what that lawsuit is really about is how to pay for the remediation, who is on the hook for that remediation. It does not have anything to do with both past remediation and if there's any remediation moving forward. It does not have anything to do with the criteria that this board is tasked with working through. In a similar vein, the environmental cleanup is something that is specifically under the jurisdiction of the Department of Environmental Services and the Environmental Protection Agency. And those are the two governmental entities with jurisdiction specifically over that environmental cleanup. There is a legal doctrine. It's called preemption. And what that means, for anyone who doesn't know, is that when the state, in this case, when they enact a comprehensive legal scheme governing something like environmental cleanup, they have done what's called preempting the field. Therefore, any subsidiary body, like this planning board or the city more generally, has no authority to regulate that, because from a legal sense, they're seen to have, all of the power comes from the state, and they are seen to have used the power that they see fit, unless they otherwise delegate power. The relevant case on that is House of Colebrook versus Town of Colebrook. During that transition time between when smoking was allowed everywhere and where smoking is allowed in no public places, the Town of Colebrook enacted an ordinance that more strictly restricted smoking in restaurants than what the state permitted, and that was found to be contrary to state law because, again, the state had preempted the field on the regulation of smoking. And this, in my mind, is clearly in that same vein. The state has enacted a really comprehensive set of laws about environmental cleanup of hazardous sites, and they have delegated no authority to the local municipalities to regulate that. And that can be contrasted with state laws relative to wetlands buffers, where, yes, there is a pretty comprehensive state scheme, but they have also delegated some powers to local municipalities to further regulate wetlands buffers. So I hope that answers your question, but if anyone has any follow-ups, I'd be happy to answer.
Any follow-up questions? Yes, Jim.
Yes, Attorney McCourt, is it fair to say that the pending lawsuit was filed so the judge can apportion liability between potential responsible parties?
I can't say why they filed it, but I think that would be the result that the plaintiffs are looking for, yes.
And one of those parties is Portsmouth?
That's correct.
And can you explain the Superfund provision that's known as joint and several liability?
This has nothing to do with this application.
Yep, absolutely. So the way that works under environmental cleanup, for example, is that anyone who previously owned the property, or anyone who takes title to the property, or anyone who contributed to the environmental hazard at the property, they are all collectively, at the same time, and on an individual basis, liable for the cleanup of the site.
And the subdivision of that land or the site plan approval of that property has nothing to do with that, is that correct?
That's correct, because the current owner of the property, whether they sell it to someone else or not, would be the same.
It'd still be liable.
They'd still be liable, whether they convey out a portion of the property or whether they do not convey out a portion of the property.
You can't create a paper tiger to walk away from it.
That's correct.
Is it also true that it's up to EPA to decide which responsible party they choose to go after, and it's often based on ability to pay?
Aren't we doing exactly what outside counsel has asked us that we should not do and speak of the lawsuit?
I think we probably are. I mean, we're getting,
Yeah,
this is interesting intellectually, but I don't think
Sure.
it's relevant for this evening's proceedings.
Yep, and I would say I am certainly, the reason why we've hired outside counsel in this case is because I'm certainly no expert on EPA regulations, and I don't know how the EPA is going to govern this, and I don't think and it is really not relevant to this discussion.
Well, I believe it is relevant, I'm sorry, because I'm trying to look out for the taxpayers of Portsmouth. And as a planning board member, I don't want to do anything that's going to increase their liability. And at this point, I'm trying to justify in my own mind how subdividing this piece of property either is going to increase or decrease the Portsmouth taxpayer liability.
Okay, I would say that is a wonderful goal to have, and I actually have the same goal, and we're working towards that same goal. And whether or not this site plan is approved, whether or not the subdivision is approved, it will have no impact, no bearing on the amount of liability that will be shifted to the Portsmouth taxpayers.
How can you say that with certainty?
This needs to stop.
Excuse me, I'm talking.
I hear you, and this needs to
Wait,
stop,
wait,
Mr.
wait,
Chairman.
wait. Just one more. Would you care to answer that question or not?
Because again, I am no expert in EPA regulations, certainly. This is as close to a EPA enforcement action as I've ever been in my career. But we have outside counsel who is steeped in this and who really knows a lot. And what they have advised is that this application that is before this board tonight will not have any impact on the pending litigation.
And with that, if we can move on to the actual matters before us. Now, if a board member feels that there's something in the environmental condition on the site that affects our site plan regulations or subdivision, then we can talk about that, but you have to be careful about that nexus. There has to really be. Yes, Jane.
Yeah, that's my question here, is that, as we go through approval of a site plan, we're going to be talking about a design that includes capping contaminated property, et cetera. I guess, how do we, I don't think we can do that and ignore the contaminated condition of the site, first of all. And second of all, so then is it open to us that we could place all kinds of conditions like that? I see that TAC said that, they must fulfill what's written in the April 26th, 2023 New Hampshire DES. I mean, that sounds good, but I don't know how that affects the design that is what we're looking at as part of the site plan approval.
We have regulations that govern lot coverage, which would tie directly to that capping criteria. So the fact that it is capping things that are being governed by state and federal agencies is beyond our jurisdiction, as the city attorney just pointed out. But if, for example, they were proposing to put in a cap that was, that exceeded the lot coverage standard, they'd need some relief from that requirement in the ordinance. Things of that nature. If there's not enough parking, if the building is too close to the lot line, if the grading was affecting the easement, which it was the prior plan, and that was been corrected. These are the sorts of things that are on the table for the planning board this evening.
And so can I, just for ultimate clarity, hopefully, so if, for instance, the cap is actually less than is needed for full remediation, and we approve that site plan with that lesser cap, do we just not worry about it? Is that under the jurisdiction of the EPA to correct? I guess I don't understand why we're doing this now, before full remediation is accomplished. That's exactly still.
I was just going to say, if we allow the applicant to present their application, they might be able to address some of these questions and answer in their presentation.
That's about where I was going.
And Mr. Chair, if I may as well, if there's some change between what is approved, if the site plan is approved tonight, and there's some change between that approval and what is ultimately dictated by DES or EPA, then the applicant would, of course, need to come back to this board and ask for an amended site plan approval.
Right.
Of course.
They have to mesh.
Correct.
But, okay.
Thanks, Trevor.
Thank you.
Thank you very much.
Thank you.
And I believe you can figure out who on your team speaks next.
Yes, I will say one quick comment and then turn it over to Joe. It's just we attempted to include in the packet various approvals that have been obtained, and so you'll find, for example, the alteration of terrain permit is at page 67, the wetlands permit at 75, so that you folks can see that those permits are already granted by the state. And I agree with the deputy city attorney that if anything that is required by any of the governing agencies changes, assuming that you folks approve what we're asking for tonight, then we would have to come back if there was some change. But I'd like to turn it over to Joe Coronati to present the plans to you folks.
Thank you.
Thank you.
Thank you, Mr. Chairman. So this property before you tonight is it's a 14.6 acre property. You can see the existing additions plan on the screen. It's on the south side of Banfield Road. It's industrially zoned. It's been industrially used for years, and we're proposing to use it industrially as well. So it's a conforming use that is in front of you tonight. We have multiple applications. As you've mentioned, we have a subdivision, we have a conditional use permit, and a site plan. The simplest is the subdivision. We'd simply like to subdivide the lot into two parcels. This is for as part of the cleanup and part of the remediation of the site and the approvals. This all ties in with the financing and the way that the site will be cleaned up. So it does not remove the client from any responsibility of the cleanup. It just simply sets it into two phases of a upland and a lowland. You've seen those terms in part of that 2,600 page document that we filed. And the upland portion of that is where the building is going. The lowland is the portion that is still to be reviewed and approved by EPA. Both lots would be conforming in size. We clearly label the lowland lot as a non-building lot. And that's important because there's not enough buildable area to construct a building on that parcel. So that's been labeled right on the subdivision plan as not a building lot. With that application, we have a couple of waivers that were noted by city staff that were part of the subdivision application, both of which refer to bonding, and I could go into it in more detail, but the simplicity of it is that the two-lot frontage subdivision requires literally no work. It's aligned on a plan, so there's no bonding needed. The off-site improvements that were actually required by the TAC committee have actually already been performed. The applicant paid to do the off-site improvements while Severino was out doing improvements to Banfield Road. So their off-site work and their off-site requirements by TAC have actually already been performed, which is unique. Most times that's something that's a condition of approval. In this case, it's something that's already been done and completed. So there's no requirements, as far as I'm aware of, for any bonding as part of the subdivision application. The next part is the site plan, which is now, well, it's about to be on the screen here. The site plan, page C2. What we're proposing is a 75,000 square foot industrial building that'll be used for high bay warehousing and office. The building's 200 by 375, rectangle. Parking is all on the west side. Loading is in the rear on the south side. We have one access from Banfield Road, and it's all the way to the west as far as we could. We spent extensive time at the Technical Advisory Committee looking at curb cuts and access to the property. Currently, if you went by it, you'd notice that there was 2 curb cuts on site now, but due to a slight rise in topo on the Banfield Road side of the east side of our lot, there's a little hill on the east side of the property that restricts sight distance. So it was determined that the best location for the driveway would be the west side of the property, which is where we have it. And we went through a couple months of designs with those, going back and forth with the Technical Advisory Committee. The site has 75 parking spaces. It has truck loading in the rear. It has, for stormwater, as it was mentioned, we already have our alteration of terrain permit. The site was also reviewed by local engineering firm CMA. They were required to review the entire application on behalf of the city. And so they also signed off on all of the design aspects of the property, the stormwater and the layout according to your regulations. The stormwater for this is comprised of a bunch of different features to create the treatment and and to obtain, as I mentioned, the alteration of terrain permit and complete the review of your regulations. So we have 4 focal points, which are stormwater treatment devices on the property. They're located, they're little, I don't know how to,
There you go.
circle. So we have one focal point here. We have another one located here. There's an additional one here, and there's 2 on this side actually for the roof water. So we have 4 focal points. That's a proprietary device. I believe you've possibly seen those in your reviews in the past. And then we have a large holding tank. It's this kind of odd-shaped rectangle under the parking lot. That's an R-tank system. So we have that comprises, so we have stormwater treatment through the focal points. and then we have stormwater detention through the R-tank system. Everything is lined. There's no infiltration allowed on the property, and there's no infiltration proposed. So everything we have to do on this site is lined, and including these two green sections. We have one green portion of the property up by Banfield Road. What this basically shows is that the existing site has existing asphalt in your 100-foot wetland buffer, and we're removing all that asphalt from the site, and we're replacing it with basically a grassed filter strip in there, and that really only handles treatment of the stormwater for the very beginning portion of our driveway, which we just have no other way to treat other than have it go across the new green space before going into the wetland. So it's a small watershed area, but it is nonetheless a wetland buffer impact, although it's really a beneficial impact. It's removing asphalt and replacing it with something that's going to be green and vegetated. The other impact that we have into the wetland buffer is just the outfall to our stormwater system, which is this green strip on the lower side. That's about 4,400 square feet. And that's really just the outfall from we obviously have to have an outfall from our stormwater system. And given the layout of this site where we have quite a bit of wetlands around the property, we have a lot of 100-foot wetland buffer. We just have to outfall it somewhere, and because of the nature of the EPA and DES requirements, is that has to be a lined, plastic lined swale for no infiltration once again. And that area of the property, if you were to look on your GIS, you have great aerial photography on your GIS every year, but you'd notice on that this area is already a meadow. It's a grassland meadow that was obviously disturbed many years ago, but currently today when you go out there, it's really just almost looks like a hay field. And that's basically what we're going to create by this outfall, is going to be a grass-lined swale. It's going to blend in with the environment. It's not impervious. We're not proposing any impervious in those areas. So that kind of relates into the aspect of the conditional use permit, which is another one of our applications that we're here for tonight. Utility-wise, Banfield Road has city water, and there's a gas line for natural gas. We're proposing to tie into both of those. We have the water is on our side of Banfield Road. We've already stubbed it into the site, knowing that when Severino was doing the work out there. And same with the gas line too, right? Was the gas line stubbed over? Yeah, so Unitil has already brought the gas line over to the property as well. For years, we've been working on this project since 2019, at least I have. For years, we've been under the realization that we were going to have to do a septic system on the property, and it wasn't until a recent meeting with city staff that it was discussed that when we started this development, the city did not own the land to the south. That was the Collaborative Learning Center area. The city since bought that piece, and St. Pat's School is to the east of us. There's a sewer line running literally right behind our rear lot line, almost right where my cursor is freezing up right here. There's a manhole right here. There's manholes, there's a trail, and there's a sewer line that runs all along here. And it was actually discussed at that recent meeting that we had with city staff that they would entertain us allowing us to tie into that sewer line So the plans you have in front of you still show a septic system. They also show a pump station and a force main running down through the easement that the city is now the recipient of. The easement is the 50-foot wide easement on the east side of our entire lot, running from basically your lot line all the way to Banfield Road. So it was discussed that that it would be acceptable to put a sewer connection into this sewer manhole. We would need to do a force main and a pump station, which we still have to design, still has to be approved by the Public Works. So that's why you're seeing both on your plan. Our intention would be to tie into the city sewer for sure, and we would forego any septic system on the property. But we just have some additional agreements that need to be put in place, a couple of which include we would need an easement from the city to be able to tie into that manhole across your property. In that discussion, we also told city staff that we would provide a slope easement along the front of our property for any sort of future use of your easement, which we were agreeable to. And I believe city staff's agreeable to the entire layout of the sewer, the easements, and we just do not have the final paperwork on all of that yet, since it came up just about a week and a half ago. We do have our alteration of terrain permit, which also granted a waiver to allow us not to infiltrate, given the fact that we have the same, we have that restriction from DES from our groundwater management permit, which does not allow us to infiltrate. So AOT approved that. There is a wetland, a small wetland on the property behind the existing buildings that has been permitted through the state for a wetland permit to fill that. So we have a wetland permit, and we have our septic approval as well. So I think at this point I'd be happy to entertain questions or go into anything in further detail.
Questions for the applicant? Yes, Jim.
Yes, Mr. Coronati, you had mentioned this project, you've been working on it for about 4 years, 3 or 4 years?
That's correct.
And for most of that time, it's been a single lot. You were just going to do the industrial warehouse thing on one lot, correct? And it's only been recently that you've decided that you want to subdivide a portion of the property, correct?
I'd say that's correct, yes.
And explain again why you want to subdivide, or why the applicant wants it subdivided?
I'll do my best, but I may have to turn it over to Mr. Graham, but would you like to explain it better? I'll let Rob explain it better.
Good evening, Rob Graham. I represent Banfield Realty. Jim, answer your question. We work with Kennebunk Bank, who is a local bank and will be financing the construction of this project. And we cannot finance a project that's not fully permitted and with ongoing permits environmentally. Therefore, the first portion of this permit, which is the upland area and what is fully permitted today, is what you see as Lot 1 and is the subdivision lot that the development area is on, while we're in ongoing permitting with the lower land area, which is Lot 2.
So your bank is saying, we'll lend you money for the permitted portion of the property, but not on the unpermitted?
Correct. You need permits to put financing on the property, yeah.
And your bank has not asked this because they don't want to lend money on contaminated property? Is that fair to say also?
Well, we need permits to do what we need to do. The permits that we have are on the upland area, and we need and the site plan permits here in that subdivision are the permits that we need to go forward and do that work.
Okay, thank you.
Thank you. Other questions for the applicant? Yes, Andrew, and then Jane.
My question could be ultimately more clerical than anything, but on page 143 of our packet, page 83 of your submission, it speaks about runoff and the runoff, or back up, it speaks about not being able to infiltrate some portions of the site due to this contamination or the groundwater existing. And then it says that runoff volume could increase by more than 0.1 acre foot due to the lack of infiltration. So I'm wondering if there's a metric that you've come up with about runoff from post-development conditions, and whether or not that's been studied, or if that's something that is a result or will be a result of remediation.
So it would take me a little bit to find that page, but I think what you're referring to is something in the alteration of terrain approval that allows for the 0.01 acre foot of volume increase. And that's a typical situation for the alteration of terrain when you have soils. Either you have soils that can't infiltrate, you just have the hydrologic soil group is such that it's a C or a D type soil where it's a non-infiltrating soil, or in this case where we have a site that we are not allowed to infiltrate, that we are allowed to have a volume increase of 0.1 acre feet. And that was looked at by alteration of terrain and approved.
Okay, so that, I guess that was my clarifying point was, is it in fact 0.1 acre feet, or is it just saying it's more than that we don't know how much more?
Oh, no, they only allow up to that.
Okay.
And we have to stay below that. And that's part of the reason why that R-tank system is almost the entire size of the parking lot.
Yeah.
Is that we have to hold that water for so long and release it to keep that volume down.
And yes, it is under the alteration of terrain. It's in the waiver request number 2, channel protection requirements. So there are 5 of them, 6 of them, of those requirements. All of those are the state of New Hampshire AOT parameters.
That's correct, yes.
Okay. That was a great clarifying point. Thank you. And then on page 154, 84 of your submission, it goes on to say that the soil management plan and the remedial action plan have concerns for human health. And I'm wondering if that is a previous letter that has since been updated, or what that means, and if you can elaborate on that.
What, sorry, is that part of the drainage analysis or part of the AOT approval?
It's a DES form dated April 21st, 2022.
I think that's part of our stormwater. Based on your page, you said it was page 150.
It's page 78, I believe, of your package. It's a letter from DES. The beginning of the letter.
Yes, so the, and sorry, once again, what was the question on the?
Sure.
Relative to the?
Yep. So it starts out by saying Sovereign Consulting Incorporated, using existing site information and surface water and sediment data, prepared a focused human health and ecological risk assessment for Wilcox and Barton. The risk assessment is included. It poses an unacceptable risk to human health for recreational trespassers that do not consume water, fish, or fish consumption without trespassing. Contamination, primarily that of lead in surface water, poses a potential risk to pelagic aquatic organisms. Contaminations, primarily that of lead in sediment, is likely toxic to benthic organisms residing in the wetlands. So is that discovery and disclosure part of your remediation plan? And if so, a lot of it is talking about the dirt that you're going to be removing during construction as well as post-development conditions. So just trying to clarify where we stop looking at that, or what is already being handled.
Yeah, so we have, that letter that you're reading from is dated is it April 21st?
Yeah, and if there's an updated version,
2022.
then just say that. That's fine too.
Right, so that letter is quite old letter, April 21st, 2022. It's a DES letter, and then it's our, it wasn't until April 26th of 2023, a year later, that we received our approval for the remedial action plan.
Okay.
And then after that, and that incorporates basically how the work on site will be handled for the cleanup, the process of the earth removal, the testing, all of those requirements. And then there's, more recently, there's a groundwater monitoring permit that's dated September 5th, 2023. And that's really the approval. The remedial action plan describes how the work will be done. And then the groundwater monitoring plan permit is basically the permit that explains really the detail that's involved by the state. And hopefully that answers your question.
Yep.
I wonder, could I just add something
You
to
certainly
that?
By all means.
And I fully appreciate why you folks are asking a lot of these questions, but what I want to sort of remind the board is that to the extent that there are concerns about pre-existing contamination on the property, that's not the question that's before the board today. That's something that, as Attorney McCord very eloquently explained, is something that's handled and must be handled by DES and EPA, and they are, and we're cooperating with them, and they're handling it. The questions before the board today are simply whether the requested subdivision, the requested work for the site plan, those changes to the property, the new buildings, whether they meet the regulations of the subdivision and the site plan regs. So to the extent that there are these issues with contamination, that's not a question for this board. So I hope that's helpful.
Certainly a forethought that we have to think about regardless of who's looking after it, just because we are the ones that sit in Portsmouth and answer to Portsmouth folks. And so it's a response to a lot of what we hear.
And that's why I started by saying I understand why folks are asking the questions. It's important that this board make its decisions based on the applications before it and the regulations that govern it. And because the regulations and the laws are very specific about who has jurisdiction over what issues, the questions of the cleanup of the contamination are not questions before this board.
Thank you. Yes, Jane?
However, in our packet, when we look at tax review of this project, one of their conditions, their second condition, is proof of cleanup responsibility. I understand that's not the same as cleanup, but that is proof of cleanup responsibility required prior to planning board approval. Do we have that?
Well, I would direct you to page 6 of the staff memo, which says the applicant has satisfied both comments above, including that one in the planning board submission. Also, that was addressed by Attorney McCord earlier this evening with regard to his advice both from the city's outside counsel and from City Council's office.
So what is the answer? Who has responsibility for cleanup? If that's already been handled, what is the answer?
Well, I'm not the city's attorney, but the city's attorney was here before you earlier and I think provided that answer. But I think, again, that's outside the jurisdiction of this board. The question before this board is not who handles the contamination. The questions before this board are whether the subdivision application and the site plan application for the new industrial building meet Portsmouth's regulations. Those are the only questions before this board tonight.
I hear what you're saying, but I also think it's very convoluted to say that that is a condition per our TAC, and then to say that it's been satisfied. And
To
as a planning
clarify-
board member, I don't understand how it's been satisfied.
Well,
so-
let me try to clarify it. TAC makes recommendations to this board, and we consider those. They're not conditions unless this board adopts them as conditions. And, I think the way I understood the explanation previously is, and based on the follow-up from Mr. Hewitt's question, in terms of responsibility, it's everybody who's ever touched it, basically. That's the way I understood the answer to the question. But
So, Mr. Chair, would you say that what TAC did was outside their authority then? TAC said, made a condition, it wasn't a recommendation. TAC said a requirement of this board is to have proof of cleanup responsibility.
They made a recommendation that, and I think it was well-founded in terms of thinking in the right direction, but it's not something we can require.
So again, they erred. They
I think
made
they
a
did.
requirement that they didn't have authority to make?
They didn't make the requirement, they made a recommendation. But we've been instructed this evening by the deputy city attorney and outside counsel that that's beyond our jurisdiction. Now, I have some questions that may relate to what's happening in the ground, but it's based on other things that are within our jurisdiction. I want to hear what other people have to say. Yes, Jane?
Okay, well, I honestly still don't understand how it's presented in our packet that has been satisfied.
Can I comment on this?
But
Yes.
I'm going to move on to another
Well,
question.
Peter Stith is on
Sure.
tack.
The concern was that during the subdivision, we wanted to ensure that the owner was responsible for both properties. And they submitted a letter follow-up to TAC that's in your packet saying that they will own both properties and be responsible for the cleanup of both properties.
And
So
that's how
was
that is
satisfying that
satisfied?
condition. Yes.
Okay, thank you.
If it's helpful, that's page 20 of our subdivision application packet letter.
That's not, I don't know what that means in my packet, sorry.
I'm sorry, I don't have the numbers
Don't feel
you
like
have.
looking
I
through the
apologize.
volume. So I have another question, but it's probably not to a lawyer.
Okay, I'll sit down then.
The engineer?
It's a question about the traffic analysis, which goes back to use, because I didn't actually hear, you did say something about what the use of the warehouse is, but I didn't hear the whatever words you used. So could you just clarify again what the actual use of the warehouse is and how that relates to how many trucks are going to be added to the volume of traffic on Banfield Road? And I ask because Banfield Road has already been, aside from all this, the focus of a lot of consternation of residents regarding truck traffic. And the city has gone out and they've tried to calm the traffic with, speed bumps, et cetera. So I think it's very important to get an accurate analysis of what this new volume of truck, not just numbers of trucks, but number of truck trips are going to be throughout the day. And I noticed that in your analysis, you only took readings at like 2 different points in the day for 2 hours at a time. You didn't really take readings of truck traffic, truck volume throughout, work days. So could you answer any of those questions?
Maybe,
I know it was a
maybe
lot.
not. I'm not a traffic engineer. The traffic work wasn't done by our firm, but the use that this is labeled as on the plan, which follows your regulations, is general manufacturing, and what's more typical of what we're seeing in the economic area of the seacoast is more of what they call high bay warehousing, which is really a taller building meant for warehousing materials. I think ever since the COVID situation where materials were hard to come by, there's been a need for companies have gone back to where they want to store material so that they have that available when it comes time to need it. We got away from that for many decades in this country, and I think COVID made a very good example of why it's needed to actually have warehousing. So we've been doing a lot of high bay warehousing, which would then have a small office component. There would be truck traffic associated with that. That was part of the off-site improvements that TAC required. We were told during the TAC process that even though the lot was zoned industrial, the road was not built to an industrial standard, and that was part of the roughly $150,000 that the applicant paid towards the road improvements, was to beef up the pavement depth and to beef up the shoulders of the road to be able to handle truck traffic. It is an industrial area. We assumed the road was built industrially, but it had to have those improvements to make it acceptable. And with that, you do have restrictions on which ways the trucks can travel along Banfield. You don't allow them to go, there's no through trucking on Banfield. And then there's routes that you want the trucks to take, and we're perfectly acceptable to those or agreeable to those routes that the trucks have to take on that road. And as far as the ultimate number, that's difficult to honestly tell you in the end what the exact number of trucks will be per day. We don't have that. I don't have that answer. Yeah.
Joe's a part of it. Again, Rob Grant for Banfield Realty. I think one of the questions.
I know, I'm looking, yeah, I'm listening, yeah. Thank you.
Yeah, no problem.
I'm listening. I'm
yeah,
just also
no.
looking at your document, that's all.
No problem, no problem. What they ask us to study in the trip analysis, and I'm a property owner, I'm not a traffic guy, but we only study a narrow window because we're studying the peaks. We study the early morning peak or the high peak or whatever the peak hours of the trip generation are in the area for the work hours. Because you don't really care about the lowest hours of traffic. You're worried about the intersections or whatever getting overloaded. We went through those conversations with TAC. There weren't concerns about trip generation, and the intersections have all been constructed in terms of turning movements and all that. Those were not the concerns. The concerns were shoulder widths and travel weights on the road. And we've been in Portsmouth for a lot of years, at least 25 to 30 years doing projects here, and we've been treated very fairly by the city in general. We worked through what the concerns were with Public Works, Dave DeFosis, and it happened that the city of Portsmouth was beginning a project to repave Banfield Road and to rework some of the cross-section of Banfield Road. We talked through what the needs were for the road. We believe in contributing for what we do for impacts and projects. Dave DeFosis spent a lot of time with Tom Severino and myself and their engineer to make some recommendations about what was needed out there. And what was needed was a 2-foot shoulder expansion on each side of the road, a deeper depth of gravel course for the road. And I don't remember if we increased pavement or not or needed to, but what Dave asked us to do, we contributed to the contract with Severino. And we completed all that work over a year ago. In good faith, again, we're citizens of Portsmouth. We're new to this property. We're here to get this work done. This project is what gets the work done to get through the remediation portion. We didn't contaminate it. We're good citizens of this community, and we will always be. The last thing, I just want to say a couple of things as the representing land ownerships. Last thing we ever want to be doing is suing a city, believe me. We're doing that out of constraints that are really remote and outside of this board, and we really don't want to be doing it, I can tell you that. We're committed to delivering a good project. The project that we proposed here is the permit to clean up this site. These permits are what are part of that remedial action plan. If we don't have these permits, we don't have an action permit to go clean it up. So we're not bad guys. We're actually the good guys here, and the only people standing in line to get this done. So we've put our foot forward again with our offsite improvements. We've dealt with that traffic issue with TAC and contributed to rebuilding that entire road.
And I appreciate that. Can I just add one extra question, which is, what about the impact on Beverly Hill Road?
We weren't asked to look further out there. There weren't concerns from TAC on Beverly. We've done what we were instructed to do, and we've done that review, and we did our improvements, and there were no further concerns from Public Works. That was that's in the minutes from our TAC review.
Thank you.
Sure.
I have other questions for the applicant. I have a couple questions for you, Joe. You didn't, you touched on it, but you didn't mention too much about how you changed your design to put a retaining wall along the side of the building, make the actual building wall part of a retaining wall, and then along your parking lot. As you go down to the southeast corner where you're talking about bringing the force main through, possibly for your sewer connection?
Yes.
Through the city easement, I notice that's, based on the grading, there's kind of, you're going to have to go through some, what looks like fill there. And,
Oh, sorry.
or just curious how, because I noticed in the discussions with DES, there's issues about how you move material around on site, where you put it, and there's some temporary stockpiling going on. How will the sewer installation affect the city's potential future use of that as a roadway? And if the city wishes to put the roadway in, will they be faced with having to address dealing with contaminated material for grading that would be needed?
Right. So I guess the first part was the sewer. We do have the sewer shown. Basically we have a gravity sewer line coming out of the back of the building to a pump station, and then a force main that runs down this way here. That whole section is higher than our site, and we were on the sheet just before this one, C3. You'll see a shaded area. We were using that as a stockpile area, and it is a big hill, which is why we need a force main. Basically going to have to,
Right.
If not, we'd end up with a very, very deep cut for the force main. So although it may work by gravity, it would just be too, construction-wise, it would be too challenging to put it in. So we were going to do a little force main for it. We have very low sewer flows. And the second part of that, with we did remove all the grading off of that portion. We do have a retaining wall. We're going to use the side of the building as a retaining wall. We previously had grading all through that easement. For years, we've been showing it that way, and I think it just kind of maybe came up recently that now that's your property, your easement. You may have some use for that, and that we shouldn't be grading it at a 3-to-1 slope. It would kind of make it challenging for you to use it in the future. As far as the work that's done on site, it all has to follow the state approvals for the remedial action plan, no matter who's doing it. So if it's us or the city, I think any work that's done on the property in the permitted area has to follow the permits. And there's a very lengthy guideline on how that's done, whether it's us or the city in the future. I think at the meeting I was at, it was, and this is probably very preliminary, it was discussed that, obviously there's a rail trail being built currently in this vicinity, and there may be someday down the road the need to put a trail on that easement to go from your property to Banfield. Obviously, you've done about a half-mile worth of sidewalk work already on Banfield. You'd have to do, maybe it's in the future plans to do more sidewalk work along Banfield. I think this would come into conjunction with all of that down the road, years from now, that you would maybe look at a trail through that easement to a sidewalk, which would then lead to the rail trail and provide more of a walkable area. But I think it's very preliminary. And I think the city staff, and I don't want to speak for them obviously, was just trying to keep in mind all the future potential possibilities for that area and not rule any of them out. And I think we've helped with that by regrading our site or keeping the grades consistent with what's out there, as well as providing a slope easement at Banfield to help any sort of future use of that.
Yes, those are helpful, and it's appreciated. My concern is if the city wishes to actually build within its easement area. You've taken care of most of it, but now if we get down to that southeast corner, you've got an area that I believe has hazardous materials as part of that pile. You can address as you need to whether that means a change or alteration terrain permit for your sewer line or not. That's within your purview, and you guys can handle that. My concern is, and tell me if I'm misspeaking here, but the city's rights, its easement's rights, are limited to the 50-foot area where it has its easement. If there's hazardous material within that easement that your permits require be located somewhere else on your property, the city has no right to do that. So my question is, if in the course of putting in the sewer line, would you regrade that so that it was more ready and available for future connection if the city chose to do it, so that the city isn't faced with an insurmountable problem?
Well, I can see Courtney wants to talk, and I don't know if I
articulated it correctly or not.
And hopefully I'm going to get at the point you're getting at. I guess what I would say from my perspective, and certainly Joe may have some comments about the sewer line itself, but the way I look at it in terms of there being an easement is the important thing here is the easement exists as it exists today, right? And whether there's contamination there or isn't, that's an existing condition. And what we're asking in the applications here, we sort of adjusted, as you know, in a way to sort of leave that easement essentially as it is now. So nothing in the application changes the city's rights as they exist in the easement. And so in that way, you know, certainly I think we've demonstrated, for example, through the recent meeting with the city to try to work out this change for the easement, that we're certainly open to trying to be reasonable and trying to find ways to make things work and trying to be cooperative with the city. And so to the extent that that comes up down the road, we don't anticipate that changing. We, you know, expect to be good partners here and try to make things work. But in terms of the applications before you folks, the important thing here is that we've made changes such that the city's easement is sort of left as it is today, and have not, through anything that's before you folks, implicated the city's easement in any negative way. So I don't know, I apologize if that doesn't address the issue.
But all of that land is incorporated in the upland draft.
Right.
All of that is in the redesign.
Right. So in the same way we've talked about before, to the extent that DES and EPA have told us what needs to be done there, it's all covered by that.
Well, I understand you're protecting your client's rights. I completely understand that. My question, since you're going to be putting a sewer easement through that area anyway, and the area to the left of it is noted as a temporary stockpile, assume you're planning to do something with that material. If in the course of installing the sewer easement, if it was regraded so that it could be used later by the city to put a road on top of it, that seems like an easy thing for you to do. It's not shown on your grading plan. That's why I raised the question.
And I'm sorry, I will turn it over to Joe in 1 second, but I'm sorry, are you asking whether the applicant agrees to move the easement outside where it exists? Is that the question?
No.
Okay. All right, my
No.
apologies.
Easement stays exactly where it is.
Yep.
It's, if you look at sheet C3, there's a little pile of material back there.
That pile is clean material.
It's
And
all clean?
that pile would be clean material. That pile is being stockpiled for potential future work where we've got to take other contaminated material off of the lower lot, and we're going to need to replace that with clean material. And that's what that stockpile is. And while we're not showing that grading on the area where the sewer line is, we have committed to where we're putting the sewer line in, prepping and constructing the gravel trail bed for the city's trail as part of it. We only agreed to that with the city in a meeting last week, and so that's why you're not seeing some of that in the grading plan.
So your plan is to regrade it to make my concern go away, basically. Is that what you're saying?
That's correct.
Okay.
Yep, and we've already committed to doing that, yes. We've agreed that with Public Works.
Okay, thank you.
Mr. Chairman, I just want to, sorry to,
Yep.
I think they're zooming in on it. We actually do note on the landscape plan, sheet L1, that we would be putting a gravel area to remain after the force main installation. You know, basically, we need access to our force main for maintenance, hopefully not anytime soon. But typically under all, as you noticed, after any cross-country sewer lines, there's always a a gravel road or a path to access that, and it was asked that when we put in that force main that we leave the city with a gravel road to sort of start, or a little gravel driveway to start your trail system, and that's what we agreed to, and that's what we noted. We don't have details on it, widths, cross sections for sure, or anything like that.
So
but-
based on our conversation we just had, is it fair that the grading plan would be revised slightly to show the change in that corner?
Not really, because there's no change to the grade. Like, we're not going to build we're just going to put basically when you install the force main, the trucks, the excavators, all the equipment that goes in there disturbs. We've got to strip off the loam. And in this case, when they get done stripping off the loam and digging the trench, they're going to leave a gravel pathway over the force main, which would be the start of somewhat of a future trail. But it would run with the land. Whatever the land is, it would run with that property. We weren't going to change the grade.
So the depth of your force main will not be deep enough to account for possible future regrading.
Well, and that's a good point. That was something that I think will come up when we design it, submit it to Public Works. I have a hunch they'll probably look at some of that future regrading, because it was already discussed at a quick level at that meeting a week ago about the section along Banfield Road. That's another tricky section because there's already a steep slope, and you'd have to, and that's where they asked for that easement, was because there's a cemetery on the abutting property. You can't excavate within 25 feet of a cemetery for state law, and so they knew that the trail would then end up pushing over more towards the western side of that easement and possibly into and that's why we came, the Public Works to ask for the slope easement. So they are thinking about it, but there has not been a design done.
Excuse me, thanks. I would just add to that the trail is, what is ultimately going to be the trail is something that even the city hasn't decided on. In our construction process, if Public Works tells us how they want that graded, we're handling that material anyway. We're going to grade that area and disturb it. And if they would like it graded a certain way, that's how we'll grade it for them.
Well, that's why you're here, and it's, I'm going to stop raising the topic. I'm concerned about it. If the board isn't concerned about it, then it's not an issue. But it seems to me where you're putting in a force main and you're going to be regrading clean material based on what you said, if you put the force main down deep enough, you're essentially grading out maybe not the full width, but at least wide enough for the trail. So instead of going over a hill that now has a force main that's maybe 3 feet deep, as opposed to being much deeper because the future grading that might happen there, then the force main wouldn't have to be moved in the future if it was down deeper. It's somewhat dependent on soil conditions. That I haven't heard it's not ledgy or anything of that nature. So
That'll all be worked out.
Yeah, I think that you're raising, salient points, and they're definitely part of what that design is. We don't know the depth of. We only found out that the city had a sewer line there that we could connect to last week. So we don't know the depth of it. We don't have any science on it. Clearly, we want our whatever depth our line is, we want enough cover over it. But as I said, we'll work with Public Works on that design. Obviously, they're going to approve that. And to the extent that we can simplify grading for the future trail for the city, that only makes sense for us to do. We're handling all of that material anyway.
okay, I'm done with the topic. Any other questions for the applicant? Yes, Bill.
Hopefully this is short. So in that loading area, I don't see any staging or parking for trucks, and the number of trucks coming and going and the size and the intensity of activity at a point in time might call for some staging area or parking area for trucks. And in the real world, what happens if you don't have enough there? They idle out on Banfield, or they go to TA.
Well, yeah.
So was the adequacy of parking for trucks on site a TAC consideration?
It is. It's based on what we propose. Clearly they're not going to be allowed to park on Banfield Road and stage. And if the size, if the tenant that comes into the site deems that's not a big enough area, then they won't select the site. Basically that's a pavement behind the building's 120 feet from the building, and it's about 180 feet wide. If they deem that that's not big enough, let's say for their trucking use, they certainly won't pick the site because we're limited, to the pavement that's shown and approved by this board. So it's a limiting factor of the sale of the use of the building.
Yes, Jane?
Does this discussion include the wetland CUP? It does,
Yes,
doesn't it?
we're talking about all three.
Okay. It's kind of an internal question because on page 5 of our, the staff memo, I see that we really don't have any guidance from the Conservation Commission outside of planting wildflower seed, and that they gave a 5-0 approval. But unless it's a typo, they did it 2 years ago in September of 2021.
That's correct.
So I guess my question is, has there been any substantial change to the packet of materials that we're seeing from whatever packet they saw 2 years ago? It just seems like a really dated approval to me. I don't know what to make of an approval that's 2 years old when the applicant has been discussing all of these, the actions that you are taking like every day, and you've been working on this since 2019.
I think I could shed some light on that.
Thanks.
You're right. Man, have we been working on this a long time. We did go back in 22, and no, the application points have not changed since we've been there. And even as late as our last TAC meeting, we had a conversation with technical review. There was a discussion about whether or not it was necessary to return back to Conservation Commission. We asked that question.
Oh, okay.
And the determination by TAC was no, nothing substantive had changed, and that they thought that it was all still relevant. And so I think you're right to raise it, and it was discussed, and as recently as at the last TAC meeting.
Okay, thank you.
Thank you. Any other questions to the applicant? So no questions to the applicant. I'm going to open the public hearing. Public hearing is open. Anybody who wishes to speak to, for, or against this application, please come to the podium, give your name and address. You have 3 minutes.
We do have one person on Zoom.
We have one person on Zoom. If nobody present wishes to join us, okay, let's have somebody on Zoom.
Kelly Shaw.
Same time limits, and no chat functions on Zoom.
Can you hear me?
Yes.
Hello? Okay,
We hear
hi.
you.
It's Kelly Shaw, Banfield Road. Can you guys hear me
Go
okay?
ahead. We hear you. Yes.
Okay, thank you. I live on 892 Banfield Road. I live in between Heritage Avenue and Ocean Avenue. It has, I know you're an industrial use, but just let me give you a quick background. It's taken me 8 years to get sidewalks and guardrails, speed bumps, speed signs on this end of Banfield Road for 8 years. Saying that, we have a conundrum because we have an air brake ordinance on Banfield Road, and by ordinance, tractor trailers and box trucks are not allowed on Banfield Road. We are still in the middle. I work with the traffic and planning and with the police department to help get some of the tractor trailers and trucks off the road because they're not allowed on the road. And I also have to work in the DOT because Ocean Road is the state road. Anyhow, I understand tractor trailers in that spot that you want to put them. However, I travel on Banfield Road, and it is a hazard every morning and every afternoon with St. Pat's there. Going around that bend, you cannot see, and during the winter, it all turns to ice. No matter how many traffic studies that are done, it's not real time of what happens on the road. My end of the road, or I say Banfield Road, between Heritage and Ocean, is considered a rural area, single residence only. There's a part of it where it goes from Heritage to Constitution down to Peverly that is zoned industrial, where in fact you can do what you want. The junkyard was there for years. But again, my concern is the direction of the traffic, the tractor trailers are going to go. If you take a left to go off on Constitution, you really can't do that because there's no signalized light at Route 1. I would like, if you want to be a good neighbor and a partner, I don't want Banfield Road between Heritage and Ocean being all for naught to have the tractor trailers come and ruin it all and make it dangerous for the people that enjoy walking on the sidewalk now. Plus, we're getting the rail trail over at this end. If we could make it so that the tractor trailers just take a right-hand turn out of Banfield Road, go down to Peverly Hill.
That's
and
your
just
time. That's
get
your
on,
time
cross
limit.
over.
I'm sorry.
I understand that, but there's no one else there, please. And go across Morona out to Route 1. And
Ms.
either
Shaw,
way,
I
on
realize there's
Banfield Road-
nobody else here, but you're supposed to stop. Let me just see if there's anybody else present or on Zoom, and then you can come back. Sorry to interrupt you,
Okay,
but
thank you.
you know, the rules are the rules. Is there anybody who would like to speak to, for, against this application, either present or on Zoom? If not, Ms. Shaw, if you'd like to continue, you may continue.
Yep.
10 minutes.
10 minutes.
Thank you. Okay, I'll make it quick. So if from that point at Banfield, either way you go off of Banfield, whether it be onto Ocean or onto Beverly Hill, to get to 95, it takes the same amount of minutes either way. So if you want to be a good neighbor, I'm just asking you to please take a right-hand turn onto Banfield, down to Beverly Hill, and cross over on Morona to get on Route 1, and there's signalized lights either way, or go to Beverly Hill to get up at the lights past the where Market Basket is. Again, 8 years of working with Eric Eby, the traffic and safety folks, the police department, and I'm still working with them. And I actually talked to Eric today in regard to signing has been is dangerous, and those women in their huge SUVs coming out of that parking lot at 8 in the morning and 2 in the afternoon is just an accident waiting to happen. So I'm just asking if this could possibly, could be an action item that you guys can take, because it's just really stressing me out because of all the work that we've done at the other end of Banfield Road. Thank you.
Thank you. Anybody else wish to speak to, for, or against this application? If not, I'm going to close the public hearing. Public hearing is closed. As a reminder for the board, because we've been talking about revising our rules, we have our motions to go through, et cetera. Our existing rules actually allow questions of the applicant after we get through this, which is not what we've been talking about, but just as a reminder. But we're not there yet. So we're ready for findings of fact, I believe.
I do want to say that I really appreciate Ms. Shaw's comments. I, too, am really concerned about the truck volume on Banfield Road. I really don't know if the solution is to, divert it to Peverly Hill Road, but we don't have any kind of traffic analysis of Peverly Hill Road or Marona Road. So I'm just saying that I think that perhaps that should be a condition of
Okay,
anything.
we're not there yet. We're not there yet.
Okay, then where are we?
That's coming up.
Okay.
We need to first get through our findings of fact, and then we,
All right, so, Mr. Chairman, I'll make a motion that, so this is actually on the subdivision waiver, so following the staff memorandum, just as it's laid out.
sorry, yes, we need to do the waivers.
Okay, so I'll make a motion that we vote to grant the requested waivers to the subdivision standards from section 9.1, improvements and installation bonds, and section 9.2, maintenance bonds. As shown in item A, strict conformity would pose an unnecessary hardship to the applicant, and the waiver would not be contrary to the spirit and intent of the regulations.
Second.
Discussion?
As the applicant pointed out, there, while there are doing improvements to the site, it's not necessarily associated with the subdivision that's being proposed, and as I can see it, the city's easement is actually not really part of that actual subdivision, so there's no additional work that the city would be subject to down the road.
In the subdivision.
In the subdivision, right.
Any other discussion? All those in favor?
Aye.
Aye.
Opposed? Waivers are granted, or waivers plural are granted.
All right, I'll make a motion. We vote to find that the subdivision application meets the standards and requirements set forth in the subdivision rules and regulations, to adopt the findings of fact as presented.
Second.
Any discussion?
Yes, I'm sorry, but I have not been convinced tonight that this subdivision will not increase Portsmouth environmental liability, so I'll be voting against.
Against the finding of fact or against the substance of the proposal, or both? You don't need to give advance notice, by the way. You can just vote, but I appreciate the explanation.
All right.
Corey, did you want to explain your? If not, you don't have to. I thought you were about ready to.
No, I may say something on the next vote, but not on this one.
Okay. Any other discussion? All those in favor?
Aye.
Aye.
Opposed?
No?
And, Mr. Chairman, I'll make a motion we vote to grant preliminary and final subdivision approval with the following stipulations, 1.1 through 1.3 as laid out in the staff memorandum.
Second.
Discussion?
So I think this is, it's a pretty straightforward subdivision. I mean, as the applicant stated, they are still retaining, the way I understood the application and what the applicant stated was that they are going to be retaining ownership over both parcels as part of the permitting, allowing them to move forward. That's the reasoning behind the subdivision. That was one of the questions I did have coming into this meeting, was why are we subdividing this? And I think the applicant did a good job explaining that.
I agree. The way I understand it, it can't get cleaned up without it. So. Yes, Andrew.
I had a question internally. With their ongoing site remediation, they'll have, whether it's monitoring wells or some sort of mechanism to monitor their site thereafter. Do we have to include any more advanced or comprehensive stipulations for monitoring and site management beyond that?
As far as I understand, it's all going to be part of what DES ultimately comes out of through their waste management program.
Sure. I didn't know if we, as the city planning board, et cetera, wanted to add in any layers or additional reporting so that we are understanding of changes to this site or any sites on Banfield that may be influenced by this site.
I think it's outside our jurisdiction.
Okay.
Any other discussion? All those in favor?
Aye.
Aye. Opposed?
Opposed.
2 opposed.
All right, make a motion we vote to find that the site plan application meets the requirements set forth in the site plan regulations 2.9 evaluation criteria and adopt the findings of fact as presented.
Second.
Any discussion?
I think this is perhaps where I would like to say that I think that we should either stipulate a limit to the number of trucks. After all, their analysis says 25.
That's next. That's next. This is,
Jeez,
I'm sorry,
okay.
this is
We're in
the,
site plan, right?
this is the statutory
findings of
change that
fact.
took effect
Oh, okay.
last year. First, you have to do the findings. Then we talk about exactly what you're bringing up. So, just on the findings. Everybody clear? All those in favor?
Aye.
Opposed? Opposed. Two opposed. You keep going, Corey.
Sure. I'll make a motion we vote to grant site plan approval with the following conditions, 1.1 through 1.6 is laid out in the staff memorandum.
Second, if I can add possibly a stipulation.
Sure.
Second at first.
Second.
You can propose an amendment.
I'd just like to add, because it's so new and we don't know whether or not they're actually going to, I think they are planning on doing the sewer connection. I just want to make sure that we add in that DPW will be approving that, so that we make sure that's part of our stipulations. I know they will anyways, but I think it's best if we actually list it as part of the conditions to be satisfied subsequent to final approval. I have one other stipulation I'd like to also add. Under, prior to the issuance of a certificate of occupancy, and I'm not entirely sure how to word this, but I want to do something to the fact that they would have to put any occupants on notice to the rules of trucks on the road, like where they can go, and I'm not quite sure how to exactly word it, so maybe some others can help me, but some sort of stipulation that they have to put anyone who's going to occupy the building, just to make sure that they've been provided written notice of the location on Banfield Road that trucks are allowed. Does that sound right? Help?
Is it the occupants, or is it going to be the truck drivers themselves?
Well, I think legally, and maybe our attorney can help us with this, I think legally we can only request that the owner notify any occupant or owner of the property, right? If there's a tenant, there's a rental, then it would be up to them to have to notify, obviously, the drivers that come. But as long as we're putting the owner on notice of our regulations and with the anticipation that the applicants will follow it, I think that legally is all we probably can do. But maybe I'm wrong.
I think the first, well, we have two proposed amendments, so let's, is there a second to the proposed amendments so we can talk about them?
She was second.
She was a second, yeah.
I was a second, so the first just has to agree.
Then you propose, that we have that, but then we have two proposed amendments to the motion with the second.
So does Corey have to accept those?
Accept it.
Yes.
Yeah.
Okay. First one seems pretty straightforward. The second one, I know we can put signs on site directing drivers where they need to go. Once they get on Banfield Road, I think they have to obey the rules of the road.
That's what I was thinking. If there's a
So
way to
add
put
signage.
like a basically a notice sign on the property, just advising the drivers of where they can and can't go. I don't know how that would look, but
Can they turn right only when they leave, right?
Well,
Or
it might just be referencing the fact that there are in fact rules, because they could change, right? One of the things I've been waiting, I know, Jane, you're going to bring up the Beverly Hill. Beverly Hill Road is going to go through a very significant widening real soon, so that, the changes, the rules of the truck paths could change dramatically over coming years, so we probably wouldn't want to be so exact about what those rules are in a notice, but just, there's a notice that there are in fact rules that need to be followed at the time.
and maybe ownership has to provide signs of whatever those rules are, whatever time if they happen to change, maybe?
Or reference to where the rules are located.
I don't want to make it too complicated.
Right.
I was trying to come
Right.
up with like a simple solution that would actually, be something that's easily done and notify all applicable parties.
That's tough. I think if there was a bridge to the left that the trucks couldn't get under, it would be logical to put a sign, right turn only. I can see the mechanics of trying to inform truck drivers with signage that might look like, a biblical text.
Yeah.
Can we, I'm sorry, could we ask that they, at the time of occupancy, that the signage reflect whatever the rules are at that time?
And be modified as.
Correct.
Yeah.
Does that make sense?
Yeah.
Whatever the rules are is pretty broad. I mean,
Yeah.
truck traffic,
Rules as
truck
applicable.
rules on Banfield Road, or
I mean, could it be as simple as like no through trucking to Ocean Road? If it's truly not allowed, and I don't know if it's truly not allowed between Heritage and Ocean, but if that's the case, then there's no through trucking to Ocean Road.
Maybe we could request that the DPW come up with a plan.
No, that makes sense, but what, I also think your request makes sense, that there be directional signage that reflects whatever those rules are, and DPW should be required to come up with those rules.
Or at least how it should be conveyed. Yeah. Maybe
how about the applicant shall discuss the topic of signage with DPW and install any sign DPW may request reflecting truck operations.
I like that. Write that down.
What he said.
I told you we needed to talk this out. I didn't have the right idea. I just had the idea. of the
Applicant
right
shall meet
words.
with DPW and discuss the topic of signage and install any sign DPW recommends associated with truck operations on Banfield Road. Now, that means if DPW doesn't want a sign, there's no sign.
Right. We're leaving it up to them, but we're expressing our concern and want for it. Okay. Yeah, I can live with that.
I as well.
Yes.
Okay, well, I think this is the place where I am struggling to find a way to talk about limiting the truck volume, because the directions, et cetera, is one aspect of traffic, but the trip analysis and the conclusions in the document we have it does have a plus in front of the 25 trucks, but it basically is referring to 25 trucks. So can we limit the number of trucks or limit the number of trucks per day out of concern for the people who live on that road?
Coincidentally,
I totally agree with Ms. Shaw. I understand her plight, and I travel on Banfield Road every single day, and I'm not trying to restrict the business, but I am trying to find some kind of, happy medium for the residents who live on that road.
Coincidentally, I looked at the traffic analysis earlier today, and through Peter Stith, had the city traffic engineer revisit the topic, because what's contained in the analysis the applicant presented uses the Institute of Transportation Engineers trip generation calculations based on the size of the building. There are other ways to do it. I'm not going to get into the weeds. The city traffic engineer looked at that. He looked at the TAC comment expressing concern that the applicant discussed earlier tonight about shoulder widening and that sort of thing that they've addressed. And the city traffic engineer was satisfied with the analysis. Now, I'll tell you, it's difficult to know what the actual truck traffic will be from this project until it's built. The variability of uses, especially at this size, is extreme, and it would be in my opinion, I think it would be a burdensome limitation, and it would be difficult to actually monitor how to measure the number of trucks. And then what do you do if X plus one leaves the site? Who's there to police that? So if there's the way that issue is addressed, if the board has a concern about traffic, they can require additional traffic analysis. That's something that can be required as a part of a site plan approval.
Well, especially since this application does not include analysis of Beverly Hill Road, and now we're talking about Marona Road. maybe we could ask for an analysis that's inclusive of those pathways.
The board could do that. In the analysis, I don't know if folks saw it, it was 25 trucks per day going 25 right, 25 left. That's what was in their analysis.
I also had another thing that I'd like to add, condition, possibly, which is under issuance of a certificate of occupancy or release of a bond 1.6. It refers specifically again to this NHDES letter dated April 26. But in our packet, I believe we have the plan that was in response, or at least partial response to that letter that's dated May 16th, 2023. So why don't we also include that? Or maybe we replace that wording with what we really mean, the final remediation action plan to be implemented or something like that. I don't know, as approved by New Hampshire DES and EPA, but I think just holding them to April 26, 2023 requirements is not a very good condition.
Well, as I mentioned earlier, based on our existing rules, we do have the ability to ask the applicant the question. I think you raise a good point. It should be whatever the DES requirements are most current, and things have changed a little bit. So
Why don't we just take out the words letter dated April 26, 2023, and just leave in with all requirements of the NHDES?
That makes sense.
That was my
that works for me.
I think that's the simplest fix.
Makes sense.
So we've had that change, 2 additional amendments. Is that correct?
Yes, that's what I have so far.
Everybody clear on where we are? Any other discussion?
Just,
Yes, Cory.
just to speak real quickly on the truck traffic, so if they are saying 25 daily each way, so 50 trucks coming and going from the site, a 10-hour day, that's 5 trucks an hour. Given the way the truck turning template was shown on their plans, it's going to be really hard to meet that threshold, given the site constraints. As Mr. Bowen pointed out, it's really tight down there where the trucks are. If they're stacked up there, it's going to be really hard for the trucks to make that. So I think that's a relatively high number for sure. And I don't see how they're going to be able to get that many trucks in and out of that site. So in one sense, I think it's good that they use, that there's a high number that they're using in part of their analysis, but physically it's going to be hard for them to meet that. So that's why I guess what I'm getting is I feel somewhat comfortable with the truck traffic that might be proposed for the site.
It's the site alone.
You think the site's going to limit it, is what you're saying?
Exactly.
And, and that's assuming a large truck. It might not be. It could be box trucks. It could be. I mean, right?
Correct. Yeah.
I had a question about if we did in fact limit numbers of truck trips to this particular site, are we having to consider it for all industrial uses on the road? In other words, can we actually just kind of spot require this? Is that a slippery slope? Would we then have to, there are other, storage facility and other buildings on the road. Would we have to consider all of them in something so?
The way it generally works, if there is a quantitative, not a qualitative reason to be concerned about something like truck traffic, and that is something that can be measured. And if you have a certain number of vehicles approaching an intersection during a peak hour, that can trigger the need for different changes with signals and turn lanes and other things like that. This isn't tonight's application, but there could be an application where a proponent may say they're going to only get this much traffic on the road, so I don't have to build that left turn lane, I don't have to put that signal in. That would be a good reason to limit the number of trips for that application, because once they exceed that threshold, or they require bonding so that when they do exceed it, like they probably will, the bonding's in place to do the improvements. Absent anything beyond, they did submit a traffic analysis, but from Steve Pernock Traffic Company. As I said, if the board is not satisfied with that, the board can ask for a peer review. The board could ask for an additional analysis. Based on what we have before us this evening, I'd be really uncomfortable with a traffic condition because there's nothing technical to base that on, in my opinion.
Well, then I think we should ask for a peer review. And the reason I ask that is not to be difficult for the applicant, but I am, I'm sitting here going, someone buys a house on Banfield Road that they live in for 25 years, let's say, and they see the nature of that road change so substantially over those 25 years. It doesn't just affect their family, their lifestyle, all that, the quiet that used to be in their neighborhood, but it's going to affect their assessment value of their actual property, that now that road, which I guess is going to be widened, I didn't know that, is just barreling with trucks. So I guess I would like a peer review so that we know for the residents on that road what kind of volume can be expected.
That's in the report. The peer review would check whether they agree with that projection.
Right.
And whatever impacts there might be. The peer review might look at what Corey brought up and what Bill raised. Would that cause a stacking on Banfield Road potentially? Again, that's a professional judgment opinion. Could be made by peer review. If that becomes a condition, it could be a condition subject to acceptance by staff, so they wouldn't have to come back to this board.
Sure.
But
I think if you were going to limit traffic on, truck traffic on Banfield Road, it would be not specific to an individual contributor to the problem. You'd have to be taking a generic look at all the traffic and impact all the people that are contributing to the traffic.
I agree.
You asked a question much better than I did. That was similar to my question, yeah. I feel the same way.
So traffic is now it could become an additional, was that a motion? So you want to have an additional condition for peer
Yes,
review of the
a
traffic?
motion to have a peer review of the included traffic analysis.
We're stacking up motions, so we'll add that one. If there's a second to that, is there a second?
Second.
Did we not have a didn't we already have a motion on the floor with a second, and we're building
We do,
stipulations?
we
we're
do.
building?
We now have
A list of stipulations.
these are conditions.
Okay.
We still have a motion pending for approval. This is a condition. As I proposed, it would be a peer review, subject to acceptance by staff. We'll have Peter read what he's got for.
Don't you have to accept the stipulations?
Yeah.
Chairman, does Corey need to accept, he needs to accept the stipulations in his motion or not, correct?
Yes,
Okay.
as an initial condition.
Correct.
Yeah, we have a proposal for, that's what I was trying to clarify.
Sorry.
It would be a peer review, traffic peer review to be presented to and accepted or by staff. So, it's to you.
Peter, do you mind just,
Right, so Councilor Monroe made two that you accepted. One, the DPW will review the sewer connection, will review and approve the sewer connection. And then the applicant shall meet and work with DPW to discuss the topic of signage and install signs that DPW recommends on Banfield Road related to truck traffic. And then the third one is to add a peer review of traffic subject to acceptance by staff. And then there's the omission of the date, April 26th, in that condition.
Could I just make a clarification to the signage piece?
Sure.
I don't believe we were asking for the signage to be placed on Banfield Road. It was as you were leaving the property. It was to inform trucks.
site.
Right, on site.
On site,
It's
okay.
on-site regarding.
On site
Very good.
regarding Banfield.
Very good.
I'm comfortable with all
You're comfortable?
as he laid it out, yes.
Okay, so we have Motion to approve, striking the date reference in 1.6, 3 conditions. Is it, if everybody's clear, we can vote as a package.
Beth has something to.
Yes?
I just want to make sure it's clear that if we're asking for staff to accept a peer review, that it's a condition subsequent to final approval, that it's in that section, that's all. So I think where we put it does make a difference. Because I had done the sign part as prior to issuance of a certificate, not prior to approval.
So you want this prior to issuance of a building permit?
For the sign, but I think the peer review needs to be prior to final approval.
Same with the sewer.
Yes, exactly. So the DPW to approve the sewer is subsequent to final approval, and along with peer review, the others would be, are all prior to the issuance of the certificate.
So right after
Just wanna
1
make
point,
sure.
right after 1.4, the DPW has more things to.
In the peer review, and then
Just to be super clear, because when you
Please.
introduced the signage piece, it was prior to issuance of certificate of occupancy, I think you said.
for the sign review,
Correct,
yes.
okay.
Yes.
Not issuance of.
Right, I had that on.
Certificate, yeah, prior to the issuance of the certificate of occupancy.
I had that under as 1.7, and then I had DPW will review and approve sewer connection as 1.5, which would be prior to issuance of a building permit.
Correct. And that's also where the peer review should come in.
Right, so that'll be 1.6, and then we'll renumber.
Yeah, you'll have to
Yep.
renumber.
Okay. Got it.
Thank you for that clarification. Are we all clear now?
I am now.
All those in favor of the package?
Aye.
Opposed?
All right, I will make a motion that we vote to find that the conditional use permit application meets the criteria set forth in section 10.1017 and adopt the findings of fact as presented.
Second.
Any discussion? All those in favor?
Aye.
Opposed?
I'll make a motion that we vote to grant the wetland conditional use permit with the following condition 1.1 as laid out in the staff memorandum.
Second.
Any discussion?
I'll speak to that just a little bit. I know, it certainly, while this is the wetland conditional use permit, there's oftentimes some, some concern over approving something in which we don't have the final state or federal permits that come into play. And so, and certainly in this case, they are still working away with NHDS on the waste management piece of things. They do have the AOT permit. They do have the wetlands permit. However, they also, will, when they go to construction, have to get a stormwater pollution prevention plan permit through the EPA as well. And so there's ongoing permits throughout this whole process that that do come up and do need to get done. And once again, I feel comfortable enough that should any of those permits change the project in any size, scale, or scope that requires them to come back to the board, then we will see it again, whether that's a wetland conditional use permit or a site plan approval. So, and once again, the people that are reviewing, those agencies are the experts when it comes to all this stuff, and so they are the ones that give the permits for them to do the work. So,
Thank you for that.
welcome.
Any other discussion? All those in favor?
Aye.
Opposed?
Opposed.
How's everybody doing? We need a
I need a break.
10-minute break?
5 is fine.
5-minute break? Okay. 5-minute break. We're going to bring the meeting back to order.
Get back to me.
Next item on our agenda is a request of Jeffrey M. and Melissa Foy as owners for property at 67 Ridges Court, requesting a wetland conditional use permit from section 10.10.17 of the zoning ordinance for construction of a new addition, reconfiguration of the existing driveway utilizing pervious pavers, installation of 3 rain gardens, and construction of stone steps and a stone patio. The project proposes a decrease of 479 square feet of impervious surfaces and is proposing 2,010 square feet of permanent impacts and 1,056 square feet of temporary impacts. The impacts will be offset by the various buffer plantings to be planted within the 25-foot vegetated buffer, as well as installation of the rain gardens to help control and filter stormwater runoff from the property and other areas upslope from the street. This property is on Assessors Map 207, Lot 59, as lines within the single residence B or SRB districts. Who is here to present this application?
Thank you, Mr. Chairman, members of the board. John Shagnon from Ambit Engineering, Haley Ward, representing the applicant, who may be on Zoom, I'm not sure, but the property, as you mentioned, is 67 Ridges Court, and we're here for a conditional use permit wetlands tonight. The project is going to decrease the impervious surface by 479 square feet on the site. There'll be 2,010 square feet of permanent impact and 1,056 square feet of temporary impact. Essentially, the project is a garage addition to an existing house over a parking area, hot top area, that's going to be removed. So we're not increasing the impervious surfaces on the lot. We're addressing any potential impacts with rain gardens and buffer plantings. Project received a variance from the Zoning Board of Adjustment on April 18th of this year, and that variance was to pull the structure front and more forward than the ordinance would allow, even though the existing structure is close to the street. Pulling the structure that is the addition closer to the street and getting a variance for that means that the buffer is more protected. The structure is going to be further away from the buffer than otherwise conforming layout would have impacted. The Conservation Commission reviewed the project on August 9th of this year, and they recommended that the Planning Board approve it subject to some conditions. One was that buffer zone markings, 3 buffer zone markings be placed. And you see the buffer sign in the lower left of your screen, and then the plan identifies the 3 locations where those signs would be posted on the property. They recommended that the applicant report to the city on the rain garden planting success after 1 year, and that the owner follow NOFA standards for landscape maintenance and planting. And all of those proposed conditions are acceptable to the applicant. In your packet is the analysis of the conditional use permit criteria. Owing to the hour, I won't go through those unless the board desires. I'm here to answer any questions and ask that you approve this conditional use permit tonight.
Questions of the applicant?
Is this addition going to have gutters, or is it going to be just coming off the roof?
There should be a note that the addition is going to have gutters that will direct the runoff from the addition to the rain garden as much as possible, and then there's some drip edges otherwise, and for the existing structure, there's the rain gardens at the toe of the slope.
Okay. That, you answered my question. I was just making sure if there were gutters that they were going to be directed to the rain gardens. Thank you.
Yes, thank you.
Yes, Jane?
Yes, all of the additions have been added into one figure, and so I was wondering, the stone patio with the stone steps, are those pervious or impervious, and what's the square footage that they add? Because they must be adding, I think, to the permanent impact.
The proposed steps and the patio that's to the east of the porch addition, is that the other area that you're talking about? So those are accounted for in the coverage table. and they're called out in the stairway number, so the stairs go from 123 square feet to 297 square feet, so that's where those are accounted for.
So that's 100 square feet addition. Is that pervious or impervious?
That's impervious, it's in the impervious surface area table. So
And-
that's 174 square feet.
And then what about the stone patio? Because that's also impervious, is that right?
The stone patio, that's existing. So it's 109 square feet existing, and actually the steps are going to take up some of the existing patio area.
Oh, okay,
So the patio is decreasing in size.
okay. Great, thank you.
Any other questions of the applicant? Seeing none, I guess I'll open the public hearing. Public hearing is open on this. I'm not going to repeat the instructions. Anybody here wish to speak to, for, or against this application? Anybody on Zoom?
No.
Last call, anybody wish to speak to, for, or against this application? I'm going to close the public hearing.
Mr. Chair, I'd make a motion that we vote to find the conditional use permit application meets the criteria set forth in section 10.101760 and to adopt the findings of fact as presented.
Second.
Discussion?
I think it's pretty straightforward. There's no place else to put this, so they're kind of the only place. So, and I think they've done a good job adding the rain gardens and plantings and really trying to make it actually better than what it was.
I agree. All those in favor?
Aye.
Opposed?
I make a motion that we vote to grant the wetland conditional use permit with the included stipulations 2.1 through 2.3.
Second.
And I see my previous points.
Any other discussion? Yes, Jane?
Can we ask a question, or is it
You
too
just
late?
did. Go ahead.
Oh, well, I mean, of the applicant, or is it too late? Because I just wish that we had a bit of clarification about whether the flood zone status of this property. I can't find it now, but I thought that I read something about how it is not in a special flood zone, but is it in any flood zone at all? I find it, I did go down and look at the actual property. It's surrounded by a lot of tidal water.
Mr. Chairman.
The flood zone is shown on sheet, the flood limits is shown on sheet C3. Yes, Corey.
That's what I was going to
Okay.
point out. Yep.
You see it?
Almost. In just a second, yep.
It comes in just above where it says proposed addition for a residence. On the left.
That's the TVZ line. Flood zone line is halfway up the yard,
Yeah,
right through the 16-inch maple.
I see.
Sorry to
yep.
blurt that out.
It's the FHC.
I don't know, I'm just unfamiliar with building a retaining wall inside a flood zone like that. So I guess if the property owner is willing to take the risk of the flood zone area and its retaining wall, it's fine with me.
It's outside of the flood zone.
It's
And
outside.
the retaining walls are existing.
Any other discussion? All those in favor?
Aye.
Aye.
Opposed? Thank you. The request of Caleb E. and Samantha L. Ginsberg as owners and Peter and Donna Splain as owners for property at 303 Bartlett Street and 295-299 Bartlett Street, requesting preliminary and final subdivision approval for a lot line relocation between tax map 162 Lot 13 and Lot 14, where a separate parcel was discovered between the two lots and is proposed to be divided between Lot 13 and 14, so that Lot 13 will increase in size from 4,906 square feet and 36 feet of frontage to 6,665 square feet and 37 feet of frontage, while Lot 14 will increase in size from 4,802 square feet and 192 feet of frontage to 8,640 square feet and 217 feet of frontage. This property is on Assessor's Map 162, lots 13 and 14, and is in the General Residence GRA District. Who is here to present this application?
Good evening, Chairman, members of the board. My name is Monica Kaiser from Hopeful, Phoenix, Gormley, and Roberts. I'm here on behalf of the Ginsburg family and the Splain family to effect this lot line adjustment. Also with me is Daniel Dadham from Ross Engineering. Daniel was involved with Alex Ross in the technical work and the survey. You have before you the existing conditions plan, and the reason legal doesn't usually come to these, but the reason I'm here is to just outline the background. If you look at the property, you'll see a T-shaped area in the middle between the two homes and on the rear side. Thanks, Peter. The Ginsburgs are on the left side of that T, and the Splains are on the right side of that T. The Ginsburgs were planning a garage addition and commissioned a survey of their property and learned that the area of the property that they were occupying and that the Splains were occupying as their own was not, in fact, theirs. So this was a situation where the configuration of these two lots did not match the tax map. And in fact, there was an area, the T area, that was left out of subsequent conveyances. The error happened, as near as I can tell, I believe in the 60s. In any event, the two neighbors got together to try to figure out how to resolve this situation, to accommodate the Ginsburg garage, and also sort of try to match existing conditions in terms of what the historical use of the property has been and how the property has been occupied. If you look on the area, the T closest to Bartlett, you can see that there's a portion of the Splain house in that T, and there's also an area in the bottom of that T where the Splains tenants park. Splains have a duplex with frontage on Meredith and Bartlett. The Ginsburgs, obviously do not. So care was taken to accommodate the existing parking that the Splain tenants have, as well as to try to get some additional space for the proposed garage that you see on the lot line adjustment plan. That garage and the setbacks to that lot line have been approved by the ZBA, I believe it was last month. And now we're just here to effect the lot line adjustment, which will essentially dissolve the T, apportion it between the two parties, and essentially clean up the issue and the tax record as well. Fortunately, none of the predecessors have been taxed disproportionately. It looks like the amount of land they were taxed on was roughly accurate, but just wasn't reflected on the ground. So now each lot will be a little bit bigger, more significantly for the duplex lot, which we thought was appropriate given that it's a duplex. So I'm happy to answer any questions. Technical questions can perhaps be answered by Daniel.
Thank you. Any questions of the applicant? Yes.
I find it a little odd that the T-shaped area that you shared between these two agreeing parties, was that like a gore, a no man's land, or how did you know that was yours to divide between your two clients?
Well, it wasn't. We discovered the issue as a result of the survey, and then we tracked down the family, the former owners of the Splain property, to to, and then we purchased the T, the four family members, you know, the Splains and the Ginsburgs purchased the T from that family. And so now the four of them own it. And that was a big ordeal. But now that we've gotten that done, we're here to apportion it between the two families.
All right.
Sorry, I think I skipped over that.
Yes, so that T was owned by somebody. at
It
one
was. I think they had long since forgot. It was as I recall, it was an estate that had been probated, and I don't think that this little T area, I mean, probably what was supposed to happen was that the T was supposed to go with one of the other properties, but, you know, somebody messed up writing a deed. But it wasn't separately inventoried in the estate of Fred and Martineau.
All right, that makes sense. Thank you.
And I did just want to address, I did see in public comment, there's a letter from Mr. Ashenhurst, who is the husband of one of the family members we purchased the tea from. He raised some concerns not understanding the frontage calculations. I think he just didn't realize that when we said 217 feet of frontage for the one lot, that we were including both Bartlett and Meredith. So I don't think there's any real concern there, and he's the only person that I know of that has submitted anything.
Thank you. Any other questions to the applicant? Seeing none, I'm going to open the public hearing. Anybody here wish to speak to, for, or against this application, or on Zoom?
No.
Last call. Anybody wish to speak to, for, or against this application? Seeing none, I'm going to close the public hearing. We have waiver request.
Yep. Mr. Chairman, I'll make a motion we vote to grant the requested waivers to the subdivision standards from section 11. Yeah. Is that supposed to be 11.5 driveways, 11.6. Oh, I'm sorry, 6.5 driveways, 6.6 drainage improvements, section 6.7 municipal water service, section 6.8 municipal service, section 6.9 installation of utilities, section 6.14 erosion and sedimentation control, section 9.1 improvements and installation bonds, and section 9.2 maintenance bonds, as shown in item B. Specific circumstances relative to the subdivision or conditions of the land in such subdivision indicate that a waiver will properly carry out the spirit and intent of the regulations.
Second.
Any discussion? Yes.
I have seen messes on title before, and what a mess this one was. So I'm really happy it's getting fixed.
It's not a condition, but please be sure those monuments get set so you don't have other encroachments in the future. Any other discussion? All those in favor?
Aye.
Opposed? Motion carries.
I'll make a motion that we vote to find that the subdivision application meets the standards and requirements set forth in the subdivision rules and regulations to adopt the findings of fact as presented.
Second.
Any discussion? All those in favor?
Aye.
Opposed? We're good.
And I will make a motion we vote to grant preliminary and final subdivision approval with the following stipulations 2.1 through 2.3 as outlined in the staff memorandum.
Second.
Any discussion?
This is definitely quite the mess, and it's good to see things like this
Get
cleaned
better.
up. So, kudos to them.
All those in favor?
Aye.
Opposed?
Thank you.
Thank you very much.
Thank you very much.
We have a request of Coventry Realty LLC as owner for property at 111 State Street, requesting a parking conditional use permit under section 10.1112.14 to allow 0 parking spaces where 48 are required. This property is located in Assessor's Map 107, Lot 50, and lies within Character District 4 and Historic Districts. Who is here to speak to this application?
Thank you, Mr. Chairman, members of the Planning Board. John Shagnon from Ambit Engineering. Haley Ward here to speak on behalf of Coventry Realty. Also here is project architect Tracy Kozak and Marie Bodie from Coventry Realty. We're asking for a parking conditional use permit approval at 111 State Street. for the conversion of some second-floor space from restaurant to residential. Some of you may recall we were here a year ago with a similar request, which was approved for reconfigure some other space within the building. The applicant spent some money and remodeled the second floor of the restaurant and tried to make that work, but the second floor restaurant space is not working. It's not providing the use that it should. So the request is to then take that 2,827 square feet of restaurant space and convert it to residential use. So we will add 2 units to the building. It was 5 units of residential that was approved just exactly a year ago. Now there'll be 7 apartments. Converting the restaurant space to residential use will actually decrease the parking demand by 25 spaces. The revised parking demand is 48 spaces. So because of the lot building to the property line and the lot build out, which cannot be changed, 0 spaces can be provided. The conditional use parking criteria, we believe, are met, and as shown in your findings of fact, we're reducing the parking need. We are making the parking demand more conforming by lessening the parking requirements. The Technical Advisory Committee recommended approval to this board of the project. The downtown location offers access to services and provides for the ability for the tenants to not need to have a full-time car to get access to things they would need. We've added some bicycle racks to the project to increase other alternative modes of transportation as required by the provisions of the conditional use parking. The site is operated with the higher demand for some time and has not caused a problem in the downtown or in the neighborhood. And finally, the peak use of the restaurant is not at the same time as the peak parking demand. I should have said the peak parking demand of the restaurant is not the same as the peak parking demand of the residential uses. So with that, Tracy Kozak will speak a little bit about the architecture.
Good evening, Tracy Kozak, Arco of Architects. Just briefly, you probably remember from last year, this project entails, what really kicked it off was an addition of, in the back, in that little courtyard, of a new fire egress stair and an elevator, as was requested by the Portsmouth Fire Department and building inspector to make the building safe and handicapped accessible. So that's what the construction is happening back there, which is the only little bit of, there was a deck, a wood deck, and wooden, dilapidated, falling apart stairway there. That's been removed, and now it's going to be much safer. Everything else, I think John mentioned about converting the dining room into 2 apartments. That's what we're here for tonight. Reducing the parking demand by 25 spaces less than it is currently. Happy to answer any questions.
Any questions for the applicant team? Yes, Jim.
Ms. Kozak, I've noted over time that you've had a few different floor plans on the second floor. I noted a few weeks ago, I don't know if it was TAC or it was 2,600 square feet with 4 bedrooms and 4 full baths. In the packet on Friday, that same apartment went to 2 bedrooms at 1,770 square feet and 3 full baths. And recently, 2 days ago, it's down to 1 bedroom, 1,200 square feet, and 2 full baths. Is that accurate?
So the square footage of the building hasn't changed. We're just, the shell of the building is not growing.
I understand that. I'm just curious. If
We
there's a
have
reason
revised
for
the
so many
interior
different
layout
floor
of-
plan changes, and why I've never heard a four-bedroom apartment having 4 full baths. I'm just curious about that concept.
So we are going, oh, go ahead.
Members of the Planning Board, Mark McNabb. Yeah, I can answer your question. We preferred to have more bedrooms, but the chief building inspector in TAC made the determination that it would have been a boarding house with the amount of bedrooms we had. So we dropped back and made less bedrooms in 2 units. So we changed for that reason.
So it's accurate to say that tonight, apartment 204 is about 1,200 square feet. It's going to be 1 bedroom and 2 full baths. Is that what you intend to build?
I don't know what the...
It's 1,170 square feet
Yep.
for an apartment.
1 bedroom and 2 full baths.
I don't think there's a 1 bedroom.
That is correct.
Oh, yeah.
Actually, it's one and,
Yeah, that's correct. That's correct.
it's two bathrooms.
You are correct about that, yes.
I'm just curious, I'm not in the rental or development business. What would prompt a 1-bedroom apartment to have 2 full baths?
Well, they're teeny, tiny bathrooms. So if you put them together as one bathroom, it's the same size as a typical bathroom, but they're separated
Toilets,
in case there's 2 people
showers,
living
2
here.
sinks. Correct?
Well, it's possible there might be 2 people living in that apartment, or even 3, but it's
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 not...
a-
Three people in 1 bed?
I'm not sure what you're asking.
Well, you just said it might be possible 3 people live in there. It's only a 1-bedroom.
Well, but it could be a couple.
You could have a parent and kids. You could have a couple,
Living in the same bedroom?
possibly.
Okay.
See, we're not allowed to make it a 2-bedroom because you can't have the separate room without a window. So the den, which has a bathroom and the other bathroom, it's a large 1-bedroom. So if you had a large 1-bedroom with 2 people working, then a husband and a wife can have their own bathroom. We're not allowed to make it another bedroom. If we could by code and law, we would. But instead, it's a large apartment. Because, see, this is an existing 2nd floor, so we can't add. It is what it is. We have to conform to zoning and conform to building code, and we're not allowed to make that a 2-bedroom because that other room doesn't have a window. And you have to have a window for a bedroom. So we decided to make it a luxury, large 1-bedroom that could facilitate 2 bathrooms. And we have the room for 2 bathrooms. We didn't want to make a bigger closet, so it was a business decision.
Does any of this change your analysis?
No.
No.
It goes by square footage, not by number of bathrooms or bedrooms.
That's correct.
Yes, Beth.
I just have, I think it's an easy question. You said how you added in bike racks. I'm wondering if there is the ability to accommodate in that area also for like mopeds and vehicles such as that.
There could be. There are 2 bike storage areas. One is outside and one is inside. I would imagine if you had a scooter, you'd keep it outside. Yeah. Yep.
Okay, great, thanks.
Yes, Jane.
We received comments that I think are pretty interesting comments from Elizabeth Bratter. And from her comments, I would like to ask about counting the prep kitchen and restaurant storage on the 1st floor into your area as constituting, in fact, a restaurant, which would affect the analysis of the parking, because the restaurant would be larger in area that way.
Yep. So the parking analysis has been adjusted to include the basement space, which applies, which is the prep kitchen. It's 170 square feet. requiring 1.7 spaces. The accessory spaces in the basement per the zoning ordinance, such as storage rooms, mechanical rooms, do not require parking. And that is updated in your submitted package.
Any other questions of the applicant? Yes, Corey.
So those two particular storage rooms in the basement, are those for the residents or for the restaurant tenant?
Well, one is for bicycles
Okay, so
on the
those-
lower right corner of the plan.
Okay.
It's a storage room for 6 bicycles. And there's a general storage room for tenants off the corridor.
Okay.
Small apartments, they need storage.
Yeah. Okay. Thank you.
Yep.
But just so that's in the record, the downtown overlay district has kind of a very strange configuration in this area. And there's the long history that I'm not going to get into tonight, but there have been several recommendations going back to at least 2010 when I was on a Blue Ribbon Committee suggesting changes to that. Did you guys look at that, have any thoughts about that, just to add it to the record?
Yeah, that's a great question. I don't know why that area of Sheaf Street was carved out on the downtown overlay district. It's awkward to me. I absolutely support it being in the downtown overlay district. I support it across the street where I own Rosa. I think was outside the downtown overlay district as well. I don't quite understand why that would be outside of it. Sheaf Street and that whole area is very dense. All the buildings in that area are, practically lot line to lot line. So I've always supported that in the downtown overlay district, but it is not in it, and I don't know why it was ever carved out.
It's been a topic, it's in my list of things that I brought to the board's attention over a year ago that we need to consider making a suggestion to council. The current downtown overlay district basically fits the way the downtown was about 1975. So, something to think about. Thank you.
And Mr. Chairman, since you brought it up, and it's an opportunity, everyone's here, it's very awkward in the downtown that was subdivided back at separation of church and state long before the automobile, where 80% of these lots are built on the lot line. It's very awkward to have a parking regulation where 80% is non-conforming. It's just, I absolutely support the downtown. The heart of the downtown should not have any parking requirements. We can't comply. We're here every time. So I would ask the planning board to look at that as well, because for a lot of the 38 years I've been here, that hasn't been the case. You had a baseline calculation. If you went less than, you didn't need to do anything. And there were times you didn't need anything. You paid an impact fee. I just want the planning board to please understand that 80% of the downtown area, the core of the downtown, is non-conforming. And we can't provide parking any more than a well or a leach field. Put it in the same camp. We're here because we have to be, but I really would encourage the planning board to relook at our relationship to parking downtown, because I think it gives the public a wrong impression, like you could provide parking and you're not doing it, and therefore someone's playing favoritism if you get it. And that's just not the case downtown. We just can't provide parking. So, thank you.
Well, to rephrase what you just said a little bit, the fact that you have to request a reduction from 48 spaces to 0 shows a lack of connection between the ordinance and the reality, in my opinion. There should not be, 48 parking spaces would eliminate the entire project. So the building would have to be raised. Yes, Bill.
Has there been a loss of parking on Sheaf Street in the recent past?
No, Marie Bodie lives on Sheaf Street, and I don't believe there has been, and Marie says there has not been.
Okay.
Yes, Peter.
Well, there hasn't been a loss of parking that you mentioned. There is a loss of parking when outside dining where Sol has taken up 4 on Chapel Street and 4 on State Street, or 2 on Chapel and 2 on State Street, 4 total spaces. It seems like a sacrifice to exchange parking here when there is demand for parking downtown, that if they're sacrificing not getting spaces for the apartments, that maybe that they shouldn't be allowed to have it for the restaurant, or it's just kind of a double-edged sword. And I have a concern about giving parking for the restaurant in that building if they're not having any parking for all the apartments at demand. Not that they need 48 spaces, but I don't know how to word what I'm trying to say, but just.
Well, in my opinion, there's a need for more public parking.
There definitely is.
Yeah,
There definitely is. And to lose 4 parking spaces when they can't accommodate their own parking needs, granted, there's none available, as you mentioned, to begin with.
There is a separate study ongoing, Parking Utilization Committee. I happen to be one of the members. There's going to be a hearing in this room on November 15th to talk about some of the preliminary findings. That group is not in the stage of making a recommendation I haven't seen any yet, for final regulatory changes, but it's moving in that direction with policies that talk about the need for more public parking and not private parking in this part of the city, the downtown, which I agree with. So I think, to your concern, Peter, I mean, this board could make a recommendation to council to consider the need for public parking as things go forward, just as a part of, but that is happening. So it is something that is going to come to council's attention shortly.
Mr. Chairman?
Yes, Jane.
As part of that parking group, have they looked at how many variances the planning board has now provided to exempt parking? Because the reality is, every time we grant one of these variances, from a city's perspective, we've just added more and more to actual parking demand. Unless they're lucky enough to get tenants that absolutely do not use cars, but
this particular one reduces it.
Right.
what did you
Current
say?
count. This
Well,
particular one-
wait. First of all, important clarification, they're not variances for parking.
Thank you.
That's really, really important here. Conditional use permits are different than variances. Variances, there's a big, big difference. Variances are much different under zoning. That's not the case here. And again, but to answer your question, yes, the Parking Utilization Committee, think about the term parking utilization. It's been looking at how many parking spaces are in the downtown, how they've been utilized, what the occupancies are at different times of day, and what the land uses are in the downtown. So,
And
yes,
has it considered how many CUPs we've granted?
it's built into the analysis because if the certain parts of the downtown are occupied based on meters more than 100%, which happens when meters are overpaid and somebody moves into the spot. And so the city gets double revenue for a short period of time when they overlap. Yeah, I know, you're happy about that. We all are. We're taxpayers. So it's built in. It's in this case, and I know you're data-driven on a lot of things, and I agree with you, it's built into the analysis that's ongoing in this part of the city.
Try to attend.
Yes, Bill?
I've got two random thoughts here. One is there are quite a number of small private parking lots downtown, and maybe even individuals renting a space of their own. And as you do another 10 here and another 30 there, those get absorbed. So part of the analysis has to be how many of those remaining private rentable spaces there are and how close to full absorption that is. There's also a perhaps related thought of below market rental rates and using parking as a leverage for getting rents for below market rate. That I guess is not our purview, but it really, I guess, would be the council's purview to deal with that. But that thread should wind through here as well.
Yeah, to your first point, the utilization of both public and private parking is part of the analysis, so that is being looked at. And to the other point, parking's expensive, so yeah, it's definitely a factor when it comes to the affordable housing issue. Any other discussion, questions with the applicant? Seeing none, I'm going to open the public hearing. Anybody here wish to speak to or against this application? As I said earlier, and as the woman presenting things knows, it's 3 minutes, 10 minutes, 10 minutes.
Bradder, property owner, 159 McDonough Street. Parking is my thing, as many of you know. I'm going to speak very briefly now, just pass that out. I just want you to take a moment to compare the existing basement plans to the proposed, and notice that the red area is pretty much the same use, and just the names have been changed. Pretty much it's a prep kitchen with a cooler, cabinets, support areas, and a support area with the back, which is pretty much a prep kitchen in any restaurant. If you've ever worked the restaurant business, you're familiar with that, except it's downstairs. So in my opinion, all of that should be included in their parking thing. The other thing that I do remember is looking at the downtown overlay district, which I included in my letter. You can see that it is very funky there, and it's my understanding that in the downtown overlay district, they are not required normally to have any parking for commercial. And I'm just putting that out there as something to think about, and I'll be back to talk to you on the second round.
Thank you. Anybody else here that wish to speak to or against this application on Zoom?
Yep, we have Bill Downing. Go ahead.
Go ahead, Bill.
Hello, Rick.
We can hear you. Your hand is raised.
Bill Downey, 67 Bow Street. As I said a year ago, most of those apartments in those areas have never had parking. I lived back in the 80s in 107, and I assure you I had no parking. Even today, most apartments do not come furnished with parking. I just don't see in this market with office space being such a soft market a viable option other than this residential option. So I'm strongly in favor of this request, and I can assure you that there's no loss or gains on Shave Street. It's always stayed the same as far as parking. Thank you very much.
Thank you.
You're welcome.
Anybody else here wish to speak to or against this application for first round? Second round?
Elizabeth Bradder, property owner, 159 McDonough Street. I only had to do 2 rounds because I had a longer letter than I thought. On May 2nd, 2023, Deer Street was granted the renewal of a parking CUP to provide 0 spaces where 7 spaces were required. These spaces had to be secured on other lots by the property management team at the time of rental. It was very generous of this board to allow a 35-space CUP reduction for this lot. And yet 111 State Street is before the board again asking for 48 spaces to be washed away. They do not show where the leftover spaces will be located if they are not approved for the extra 13 spaces. And they do not show where the 9 needed spaces are going to be found for the residents who live there. Please bring up Plan PB01. It's on page 2,786 of the packet. Notice that there was an area in the back for parking. And now it's proposed to have lots of building back there. Now, they say that they needed to do that in order to meet other requirements. But if you look at the proposed plan versus that plan, you can notice that the new plan, which is on page 2,790, they could have pushed that stuff back inside. But they chose not to do that. They choose to expand it out there. And probably makes it look nicer, but it's just a reality of this. So if you look at the existing spaces in the back, you could probably fit a minimum of 4 stacked parking spaces back there, possibly 5. Now, there are no measurements on this thing, so what I had to do is take out my trusty little ruler, get out the legend that they have at the bottom, and measure and see whether or not you could fit that. I made the parking spaces 10 feet wide because it's easier to measure that way, and 19 feet long. In an environmental city like Portsmouth, reducing circling of cars for parking spaces is very important. Not providing any residential parking in downtown is a totally unacceptable idea. We have had tenants who work within walking distance or work in the restaurant business. All have had at least one car or a motorcycle to get to work, medical care, and to enjoy New Hampshire. Residential units should meet the minimum parking requirements because Portsmouth changed them to be able to deal with the downtown area. For the smaller apartments, they lowered the parking required significantly. Portsmouth creates circling for long periods of time to find a place to park sorry about that. Residential units should have the parking because Portsmouth often creates this circling problem that happens when people are looking for a place to park in the evening, especially in the winter when no one wants to walk down an icy road with their groceries. Please do not approve this reduction in parking. Even with the change to the residential, they are not able to meet the criteria for a CUP. In 10-12-142 is not met. This is a new proposal with the change of configuration of the use of the building. The proposal has still not brought the parking demand down to the 35 spaces they were granted last time. And actually, they do not show how big or why the basement prep kitchen is not included. 112-143 is not met. It is clear that there is no off-street parking, and therefore what they are presenting is not adequate for the proposed use. It does not meet any of the minimum requirements, even with the existing 35 space reduction. 112-144 is not met. This section is very applicable, although it is stated it is not, because not a single minimum for both the restaurant or the residential has been met. The board can allow fewer than the maximum, but it does not state that the board can allow none. Even with 35 space reduction, they are still short 13 spaces, much less if you count the prep kitchen. It is clear that both the size of the restaurant and the amount of residential is too much for this lot. Other lots have been denied CUPs, even providing parking on site. Please deny this CUP and have them go back to the drawing board to balance out the use of the space of the lot to at least provide the minimum for the residential area. Thank you.
Thank you. Anybody else wish to speak to, for, or against this application? Yes, John.
Yes, Mr. Chairman, just to sort of bring the record up clearly, we were here a year ago for a different application, which was 35 spaces, and the numbers at that time were based on the interpretation of the then planning director that the number of spaces, the 35, was going to be calculated by looking at only the portions of the building that were changing at that time, not the entire building. So the 48 now, to clean up the record and go forward, as the entire building is now calculated. The change that is proposed is a decrease in parking because you're going from a 25, I believe, to 2.5. So it sounds like this application is for more relief, but just need to explain that it really is not. It's just how it was treated in the last application. I hope that that makes it clear. Thank you.
Thank you. Anybody else? wish to speak to for or against this application?
Bill Downey, did you had your hand raised for a second there? I don't know if, here he goes. Go ahead, Bill.
Bill, you on Zoom? Was it a mistake?
No, I'm here. I just wanted to make the argument that if the number is reduced. Yes. Nope, can you hear me?
Yes. We can hear you. We can hear somebody else, too.
That, if the number is reduced.
You're getting very distant.
Can you hear me okay?
Now you're good.
Okay, so I apologize.
Yeah, there's something going on.
I don't know what to tell you.
Now you're...
Just tell us.
Just,
I apologize.
Turn his TV off.
yeah, is your TV on?
Yeah.
Turn it off.
Okay, I'm turning it off. Can you hear me okay?
Now, yeah, go ahead.
Okay. My apologies. If you reduce the number of units, they're just going to become more bourgeois. Those folks are going to be able to spend $300, $400, $500 for parking. I know this stuff inside and out. I've lived downtown for over a quarter of a century. If the units are at least affordable, you know, people have to learn how to hustle, how to find a place. By this support, I'm only increasing competition for myself because you know I live on Bow Street. But I just feel with all the factors, all the elements we've discussed, this is a downtown location that forever was residential. It's only in the last probably 10 or dozen years it became anything other than that. So I really believe in this case, this request is reasonable, and I believe that we need more apartments in the community. We've all been talking about this. No such thing as affordable in Portsmouth that I understand, but at least it's headed in the right direction versus something that's $3,000, $4,000, $5,000 a unit. That's it.
Thank you.
You're welcome.
Is there anybody else wish to speak to for or against this application? Anybody third round? Going to close the public hearing. Public hearing is closed.
Mr. Chairman, I'll make a motion that we vote to find that the conditional use permit application meets the criteria set forth in section 10.1112.14 and adopt the findings of fact as presented.
Second.
Any discussion? Yes, Jane.
I have a question that's just relevant to this, which is with that Deer Street property, I do remember that they came back and said that they could not find, you know, parking spaces for their potential renters. But then what happened? Then we excused them
I'll
from that?
explain that
'Cause-
once we get, this is findings of fact. I'll explain that when we get to
Oh,
the,
it's finding facts. yeah,
remember,
okay, sure.
findings of fact
Sorry.
first. All those in favor?
Aye.
Opposed?
I'll make a motion we vote to grant the conditional use permit as presented.
Second.
Discussion.
Could you just review with us what actually was the final outcome with the Deer Street property?
My recollection, and that's dangerous, but my recollection is that based on the second application and the applicant's explanation that they could not secure those off-site spaces, that the board approved it. And you have some additional,
Well, it was, their issue is they couldn't do it prior to getting occupancy. And that was the big issue, is that they, in order for them to get their certificate of occupancy, they couldn't get the parking prior to. So that was the issue when we had made that original stipulation.
But we did end up granting the CUPs, okay?
yes. And Andrew, you had your hand up.
Yeah, I think it's an opportunity to reflect on some of our parking code and ordinance. I'm not unwilling to see the opportunity that this particular project and applicant are proposing, but I'm unwilling to just let it slide by in the future. I think that it sets a very scary precedent for property owners downtown who may fall inside or outside of this overlay district to reposition their properties and take advantage of some of these parking precedents that we are setting, whether it be Deer Street or this project. Why I find myself being more willing in this scenario is that I know this particular applicant has a strong history with J1 visas and utilizing a lot of that employment throughout certain restaurants. And so that, to me, seems like a very viable and worthwhile opportunity to complete that full cycle ecosystem for that business and that investment. But if it's not that case and it's simply just a one-off property owner looking to get reduced parking down to zero, we then create quite a snowball effect that whether you're on Sheaf Street or Deer Street or anywhere in this downtown proper area, there's no end to that. And we should find a very concrete solution to that, because more and more of these private parking areas, i.e. Citizens Bank, have become purchased and will ultimately become developed, and some of these spaces will get lost, and that again will come back to us, and we will hear the fact that we have set a precedent on projects very similar to this, and it will create a really big disruption in how property developers look at downtown. With that said, it is absolutely the case that people bike, walk, and park elsewhere to get to these restaurants when they work in the service industry. It would be naive for restaurant owners to think that their employees will just figure it out, quote unquote. So my point in this is that we should certainly take a look at these parking ordinances to eliminate any loopholes or discrepancies in the future, because downtown will become significantly more chaotic if restaurants rely on something to this effect in the future.
It's late. I don't want to take a lot of time. I'm just going to say quickly a couple of things. This is directly related to the public policy of providing public parking.
Sure.
And the question is, I can tell you that the state of the practice today in downtowns and smart growth is you do not require parking in an environment like this by the private owner. There are many reasons you don't, but one of the reasons is private parking is private. It's not shared. Public parking is shared, so you need less of it. And as a shared resource, it's much like sewer, water, other infrastructure. That's the way to treat it in this environment. And I'm not going to say too much more, but that's the long term. The long term is a dialogue with the council to help create more public parking. And Beth has her hand up.
Yeah, I'd just like to say that I'm in full support of this, because I have a feeling that based off of numbers we've even gotten on properties over on Middle Street, that a lot of these people don't actually have cars, and the few that do will hopefully give the city more money by renting spaces in our parking garage, because that's what we like to see, is more parking revenue. And there's lots of public transportation. There's the opportunity for other modes of transportation when you're living in an urban environment, and I think that we do need to relook at all of our zoning as far as parking goes. As I've stated on several times very recently, our downtown is very different than our West End, which is very different from more rural neighborhoods, and we need to have zoning that actually reflects the area that it's affecting. And so I think that that should be where we head in the future.
Jim, and then you're back to you, Andrew. First, Jim.
Yeah, I'm sorry, I can't support the CUP for a couple reasons. I think I had a long-standing issue with our parking rates to begin with. I think everyone is well aware of that. I think the number of bedrooms is a much better indicator than parking demand in apartment area. That was well established at West End Yards, and I don't believe at least some of these apartments are going to stay one bedroom. I think particularly this one I spoke of during public hearing, I don't think that's going to stay at but one bedroom. I think there's going to be more bedrooms in there and more parking demand. So for that reasons, I can't support this.
Okay, thank you. Yes, Andrew.
And simply just to complete my thought, I get the opportunity to amend some ordinances and how it's certainly not efficient to require parking because we don't want to drive, or no pun intended, we don't want to have to increase the demand for car traffic, right? But it also passes on to private property owners and the neighbors, which this is a very heavily residential area. So some of those folks may be impacted and have some unrest towards that. And to Beth's point, the West End and downtown and Islington Street areas, or Middle Street for that matter, those are all in the same situation where, yes, we can do this. We've had some data that says not all of them have cars, but I do worry about some of that disruption with the neighborhoods and the residential private property owners that will have to just consciously think about, oh, is someone be blocking my driveway? Is someone going to take my parking spot? And I don't want to create that for people because I know that they probably enjoy living downtown very much. And so just to be cognizant of not only this property, but surrounding properties that could be impacted by this residual type of approval.
Have your hand up.
So, back to my point before, or question before, are we able to stipulate that you can't? You know what I mean?
Can't tie outdoor dining to this, no.
I mean, you're giving up 4 public spaces though for that, and then you're not providing any parking, and it just seems contradictory, and that's a concern I have.
That's a separate policy question,
Mhm.
I
Can we
think.
call a question?
Just a comment, I'm glad that we're talking about the differences in our boroughs and neighborhoods, because I don't fear a precedent being set so much because there's never been parking in these areas for such a long time. And some of our most prized streets and locations downtown, whether it's Commercial Row overlooking the tugboats, Market Street, there's just no parking at all. It's almost the character of downtown. It wasn't designed for vehicles, and bringing more vehicles and accommodating vehicles in the historic core
Sure.
is treated very differently than West End Yards or other neighborhoods. So I'm glad that we're recognizing the differences, that's all.
The reason I brought it up is because this was previously approved as a restaurant site
Yeah.
where there are certain stipulations, and then to change it into residential and ask for that waiver,
Yeah, understood.
that's where my internal conflict is created. But
Okay, I let everybody go past 10 o'clock.
Yeah.
And
Yeah, well past.
thankfully, I did split the agenda. I'm going to call the question. Is everybody in favor?
are we voting?
Are you calling the vote?
Yeah, I'm going to call the vote.
Oh,
Yeah.
sorry, is this to go back past 10 o'clock?
Not the vote on 10 o'clock. I think we're ready to vote on this application.
Sorry,
There's a
okay.
motion in a second already, correct?
Yes.
I think there was a while
Okay, so-
ago.
Motion, you seconded.
I
That's
apologize.
right. So, you're right,
All
it is
those
late.
all those in favor?
Aye.
Opposed?
Opposed.
2 opposed. And Jane, did you vote?
No.
Was that an abstention?
Yes, it's an abstention.
All right, can we move
I can't vote in either direction. I agree with the points that I've heard on the negative side as well. I think this is a problem with our zoning ordinance being, again, so far out of whack with changes that are already occurring in the downtown area. I don't want to set a precedent for saying yes or no. Sorry, I am going to abstain.
Can we move on, Mr. Chairman? It's late. Can we just?
I think the only,
Wait, 2 more.
oh, 2 more?
Yes.
We have 2 more.
Sorry.
Parking rules.
I think you're all set. Thank you.
Yeah, thank you very much. So I can find the darn thing. We're on to Hofstra. Request of Marcella F. Hoekstra as owner for property at 35 Whipple Court, requesting a conditional use permit as permitted under Section 10814 to allow a detached accessory dwelling unit. This property is on Assessor's Map 260, Lot 98, is in the Single Residence SRB District. Who is here to present for this application?
Good evening again, Chair Chelman, members of the board. Monica Kaiser from Hopeful Phoenix, Gormley and Roberts. With me is Marcella Huckstra, owner of the property at 35 Whipple. I hope this is a simple application. Marcella has an existing modest single-family home on that sort of triangular shaped lot. There is an existing detached garage structure on the lot. She's intending to put a small ADU in a portion of that structure. And that's about the size of it. I have submitted a written memorandum outlining the criteria and indicating how we meet it and what the specific issues are. I know it's late. I don't want to read through it if I don't have to. I know
You don't
also,
have to.
Okay, good.
Thank you.
But I'm happy to entertain any questions. One of the things we are asking for is a waiver from the parking requirement. And what I can say about that is that Marcella is a single mom, so she's the only adult lives in her house with her daughter. This ADU is likely to be, at least initially, maybe for her father or, potentially a tenant. There's kind of enough space to get 2 small cars in there, but there's not enough space to get 2 compliant parking spaces. I think, given the small size of the house, the fact that it's a single owner, that works out in this case. She has, I know I submitted to the zoning board, I could give to you as well if I didn't give it to you. There's a number of abutting owners who were contacted and who support the proposal. I can hand that out if you want for the record. It's almost everybody in the immediate neighborhood. I think there's one owner across the street that she could not make contact with. If I can approach.
While those are being passed out, any questions for the applicant?
I have one more if anybody needs it.
That you're
Yeah, I mean, it's about the size of it. I think the staff memo makes clear that there were some issues with the garage that's been resolved via an equitable waiver. ADU is under 400 square feet, so quite small, likely only going to be a single occupant.
Okay. Any questions, the applicant? Yes.
One quick question. On the plot details, you show that there's going to be some asphalt removed in front of the garage?
Yeah, just a small section, just to have some plantings there, so it doesn't.
Oh, okay.
You know what I mean? So it just beautifies the area for the occupant of the ADU, not a significant portion. Is that right?
Okay, thank you.
Any other questions? Seeing none, I'm going to open the public hearing. Public hearing is open. Anybody here or on Zoom wish to speak to, for, or against this application? Nobody on Zoom?
Nobody on Zoom.
Last call. I'm going to close the public hearing.
Mr. Chair, I'd make a motion we vote to find the conditional use permit application meets criteria set forth in section 10.814.62 and adopt the findings of facts as presented.
Second.
Any discussion? All those in favor?
Aye.
Opposed?
Mr. Chair, I'd continue to make a motion that we vote to grant the conditional use permit with a modification to the requirement set forth in section 10.814.26 to not require an additional parking space for the detached ADU, ADU, and to approve the conditional use permit with the following stipulation 2.1 regarding certificate of use from the planning department.
Second.
Any discussion?
Good neighbors.
I actually was looking at this and trying to figure out why it actually needed to come before us, but then realized it's the parking. That's actually why. I think this is exactly, the kinds of things that we want homeowners to be able to do, especially to make their homes more affordable. That's why I tried to simplify the ADU and why we worked on that so hard, and I think this is a really good example, and very happy to approve it, and thank you.
All those, yeah, whoa. Yes, Bill.
So I think virtually everybody is probably in favor of this proposal. On the other hand, the next person that comes in, I can't imagine any less deserving, not to prejudice this, but almost anybody that comes in asking for one is going to have at least this hurdle of benefit that they can point to. So the question really would be, can we ask the city council to change the rule if the answer is that the rule says there has to be one, and everybody says we don't really mean that? Can we ask the city council to change the rule?
We could, but, I mean, it depends on the geometry in each site. I think that's why it's in there. There was a lot of discussion about that topic at the Land Use Committee, so, but yes, that is a change that could be requested. Joe, you
I
have
was just pointing to Councilor has a comment.
Well, just to further state, I mean, this is on a small cul-de-sac where there's clearly plenty, and I don't think, I've been in this neighborhood before. There's not a whole lot of people even parking on the side of the road. So I think that we're in a neighborhood where you can point to and say, there's plenty of off-street parking. This isn't a really tight neighborhood where it's going to be a burden on the neighborhood to have not that extra parking spot. And there was a ton of discussion at every level of approval of the ADUs. And originally, we didn't want to add parking requirements, but it was really public feedback that really insisted that we add in a required parking space for the ADUs. So unfortunately, because of that, yes, could the city council change it? There were actually a couple of city councilors that were really pushing for that, but the public really pushed back, and so therefore we left it in there. But I think it's then becomes the discretion of this board to look at a situation such as this where you probably can fit 2 cars, but you also probably have plenty of off-street parking right there in the neighborhood that won't cause a burden.
Good. Well done. All those in favor?
Aye.
Opposed? Thank you very much.
Thanks for waiting.
All right, moving right along. Next one. Did we just repeat the vote?
One more.
Because we did one.
Request of Richard and Jessica Hayes as owners and William and Katia Becker as owners for property at 40 Walker Bungalow Court and 26 Walker Bungalow Road. Sorry, both road. Requesting preliminary final subdivision approval for a lot line relocation to remove the encroachment of a driveway and retaining wall as follows. Tax map 222, lot 5-1, consisting of 53,970 square feet of lot area, increasing in frontage from 140 feet to 160 and 1700 feet with no change in lot area. Tax map 222, lot 5-2, consisting of 37,637 square feet, decreasing in frontage from 120 and 1700 feet to 100 feet with no change in lot area. Properties on Assessor's Map, lot 222, lots 5-1 and 5-2, and is in the SRB district. Who is here to present this application?
Good evening. My name is Richard Hayes. I live on 40 Walker Bungalow Road. I'm here on behalf of my wife and our neighbors, the Beckers. The proposal in front of you from Ross Engineering solves an issue of encroachment where our driveway and 15-foot retaining wall is located on the Beckers' property. We're looking for your approval of a land swap and a movement of the line between our 2 properties, which eliminates the encroachment. So that's what we are proposing and would like your approval.
Any questions to the applicant?
Might be the simplest application of the night, unfortunately. You have to wait till the end.
So sorry.
That's all right.
Thank you. I'm going to open the public hearing. If anybody here or on Zoom wish to speak to, for, or against this application? Seeing none, I'm going to close the public hearing.
I'll make a motion we vote to grant the requested waivers of the subdivision standards from section 6.3 streets, section 6.4 curbing, section 6.5 driveways, 6.6 drainage improvements, section 6.7 municipal water service, section 6.8 municipal service, section 6.9 installation of utilities, section 6.14 erosion and sedimentation control, section 9.1 improvements and installation bonds, and section 9.2 maintenance bonds Following option B, specific circumstances relative to the subdivision or conditions of the land in such subdivision indicate that the waiver will properly carry out the spirit and intent of the regulations.
Second.
Discussion? All those in favor?
Aye.
Opposed? Waivers granted.
Oh, carry on to make a motion that we vote to find that the subdivision application meets the standards and requirements set forth in the subdivision rules and regulations and to adopt the findings of fact as presented.
Second.
Discussion? All those in favor?
Aye.
Opposed?
I'll make a motion we vote to grant preliminary and final subdivision approval with the following stipulations 2.1 through 2.3 as outlined in the staff memorandum.
Second.
Any discussion?
As Joe pointed out, this is a very simple request.
All those in favor?
Aye.
Opposed? Carries. Thank you very much.
Thanks for your patience.
There was only one other item, a council refer.
Yep, you're good.
We're doing more?
Well, actually, it's two items. We have to, Lonza's requested a continuance to November 15th? 16th?
To the November meeting.
To the November meeting. Need a motion to that effect?
So moved.
Second. Any discussion? All those in favor?
Aye.
Opposed? And the last thing, can this council referral wait a week, or do we have to do this one? It's really quick. It's just a right away. It's just a referral.
Go for it.
Motion to recommend to council we accept the right-of-way easement on Grays Lane.
So moved.
Second.
Any discussion? All those in favor?
Aye.
Aye.
Thank you very much. I'm going to adjourn the meeting. I'm not going to even say.
Can we just? I would like to confirm a quorum for Thursday, because I know we have
I'm not.
2 absences already. Is everyone else able to make it next Thursday?
Take it.
Believe so.
Okay. All right. Thanks.
26.
26.
Now we're really
All right.
I know.